Once a person has been appointed, has been medically categorized, can be eliminated or be placed elsewhere. This issue has been decided by the Supreme Court. Several judges, the issue has been decided. So it will not take much time. 20 the petition is aging. Ultimately, he is not. It's a 2018 matter. 2018 matter. Then why until now it has not been taken up? Not taken up, my lord. It's no, my lord. Pleading is complete, my lord. Affidavits have been exchanged. No, my lord, it was appearing prior to vacation in the monthly list, my lord. Now so it will come in the monthly list. My lord, inclusion monthly list.
My lord, may I crave your lordship's can leave position one, my lord, tribunal application. Here, my lordship would come to know from this determination that there is only one administrative member in the state administrative tribunal. There is no judicial member for about now 1.5 years or 2 years. Now, my lord, the litigants, my lord, one of the prayers before this honorable court in this tribunal application would be for appointment of an honorable judicial member or to expedite the process of appointment. Now, my lord, there was already a two matters were being
How
moved.
that matter will be considered by this bench?
There is a division bench judgment.
No, by this bench, whether it is to be considered by this bench. This bench is to take up.
Is of the view that this should be considered before the honorable.
It is on the list.
No, it is not on the list. I am praying for inclusion. If your lordship is of the view that this cannot be considered by this,
it is for you to know. It is for you to know which bench to mention before.
I have filed. This is a tribunal application. Now, I cannot.
Not a tribunal application.
I cannot file public interest litigation in view of the fact that we are interested parties. We are litigants before the state administrative tribunal.
So your matter has been decided by the tribunal.
No, it has not been decided. That is my grievance. That for about 1.5 years, my matter is not being decided. That is why I have come in 226 to 27.
What have you filed? Co-warranto? You have filed prohibition? What have you filed?
I filed a 226 to 27 application following L. Chandra Kumar saying that there should be an overall guidance of the Honorable High Court vis-a-vis all matters of tribunal. Now, if your lordship is of the view
that direction, whether it can be issued by us or it is to be done by the PIL bench,
there is already a division.
That is for you to decide.
Justice Horish Tandon Manal, sitting in this court, my lord, his lordship was pleased to direct that the process should be expedited. Now, if your lordship is of the view that this cannot be done in an adversarial nature and this should be done by the other bench, my lord, the lordship may kindly.
We are not going to direct anything. You may mention wherever you think is appropriate.
Well, kindly, I am mentioning it before your lordship.
Sorry.
If your lordship is.
We don't think so.
Then
you
kindly
may mention
wherever. One line.
Once we say we cannot do it, we will not pass any order. The matter is to be taken up by the bench, which is to consider the issue.
I have filed tribunal application before law.
See, anything which is not before us in the determination, you cannot mention and ask us to pass an order that you go before this bench.
I
cannot.
Filed in your lordship's determination.
Let us see.
When it comes up previously also by the honorable division bench decided.
What happened? What happened then?
Well, two matters were being heard.
Your matter was taken up.
Yes.
What happened then?
There were two matters. In one matter, the judgment has been passed for expeditious appointment of a judicial member. Now, in my matter, my lord, I'll be praying for the same relief.
Then why do you need the same relief? It is already there.
It has not yet been done. It is about 1 year ago. This
we'll see. Not right now. Yes. Hearing we'll see will right now be included in the monthly list only.
Lordship, may I be permitted to mention a matter? So this matter was, there was a delay of 5,437 days. The matter was, Mr. Mukherjee was leading me. And other side was Mr. Aniruddha Chatterjee. Lordship, this matter was heard at length on numerous occasions. Our reply was, we were giving our
Why are
reply.
you mentioning right?
Lordship, determination has changed and this bench has already heard the matter at length and it has, Lordship was pleased to fix it on 12th of this month. Now the determination has changed.
Can be done.
That is the main difficulty we are having.
Not a tied up matter, therefore what can be done? Have to be considered by the bench wherever it is.
Lordship can fixes. Your Lordship takes up this matter because it is heard at length before this bench.
We understand
On-
your difficulty, but it is not a tied up matter. It's not a part-heard matter. Therefore, we cannot pass any order in that. If it had been a part-heard matter, we could have done so. Yes,
I can understand the prerogatives of this bench, but
we know that you understand. Therefore, we are saying.
as your
Please,
Lordship,
next,
as your Lordship.
all the list.
Item number 1,
My Lord, I am
So I
praying
have
for
got
not this week on behalf of Sonojit Kumar Ghosh appearing for the respondent.
so I have for the appellant petitioner. Ma'am.
Yes,
My Lord, I am praying for not this week on behalf of Sonojit Kumar Ghosh appearing for the
can't hear you. Can you switch on the mic? Are you using the mic?
praying for not this week on behalf of Sonojit Kumar Ghosh appearing for the respondents due to illness. My Lord, he is unable to come.
What is it? Let us see.
So this is a matter in a short way, my lord. May I say, my lord, one agreement has been executed with the Southeastern Rail. Now, my lord, that agreement says that there will be a parcel space which I will be operating.
There will be a
Parcel space in connection with the concerned train, which has been put in auction, and I was adjudged as the highest bidder, and I was conferred with an agreement, which is the e-auction agreement. The validity of the e-auction agreement is for 2 years. Now, my lord, before entering into an e-auction agreement, all the cost components have been duly inserted in the agreement, which needs to be followed up by both the railways, one by the Southeastern Railway and the Central Railway. Now, my lord, Central Railway in the meantime, during the operation of the contract, has come up with a office memorandum where they sought to increase the freight charges by imposing a new charge, that is a scanning charge. Now, my lord, challenging that, I approached before this Honorable High Court saying that it is against the policy of the railways. The policy itself says it's quite clear and unambiguous that I may opt for scanning charges, I may not opt for the scanning charges.
What is
But it
this
is not
scanning what is this scanning charge?
scanning charge, my lord, before loading the parcels.
Okay.
Loading the parcels in the parcel space, my lord, the railways have taken a decision that the petitioner, if they have their own facility at their own office, then it has to be tagged, then no scanning charges will be levied. Or if I opt to scan those charges at the facility installed in the railways, then I may pay the charges. But if I do not opt to pay any scanning charges,
So if you set off in your infrastructure, you are not required to pay. If you use their infrastructure,
Yes.
you are required to pay.
I require to pay. But if I say that I do not intend to scan, but subsequently it is found that I am carrying on some contraband items, which is not permissible, then I face consequences under the law. But here they cannot say that I have to mandatorily use the railways facilities, because it is very much clear from the policy, my lord, that I may not.
So
Lordship,
what happened? What happened before the Honorable Single Judge?
before the Honorable Single Bench, my lord, a similar matter, my lord, prior to this, similar matter between the same parties, my lord, writ petition was filed and it was dismissed on the ground of territorial jurisdiction. Now, my lord, it was taken into appeal before the Honorable Division Bench. My lord, Lordship, kindly come to page 136. Page 136, my lord. Well, this was the order of the Honorable Division Bench over this issue.
Yes, so that the same principle as section 20 CPC has to be applied,
Now, my lord,
whether the cause of action in part or in whole,
yes,
as a reason.
I have pleaded the cause of action, and I have also pleaded the grounds.
What is the cause of action?
And the bundle of facts, my lord, which I have.
Is that cause of action which you say has arisen before the court
Because the agreement has been executed here. The notification which has been published by the Central Railway is rewriting the agreement which has already been entered and executed and accepted. And it is a stipulated clause in
Agreement is executed here.
executed here.
Where is
The
that? Let us see.
My lord, kindly come to the agreement at page 62. Yes, page 62, my lord, kindly see Kharagpur Division. Southeastern Railway having his head office at Garden Ridge, Kolkata.
That is the name of the lessor. That does not mean the agreement has been executed here. You said the agreement has been executed here. So let us
Executed
see.
within the jurisdiction of West Bengal.
Where is that?
My lord, page 62, my lord, kindly see the lesser Kharagpur Division.
That is the name.
Southeastern Railway.
That is the name of the lessor. That is not the name of. That is not the place where the agreement has been executed.
My lord, kindly see the page 64.
The lessor can be anywhere, but he may execute an agreement any other place also.
My lord, here in the railways, my lord.
So therefore, you said agreement has been executed here within the jurisdiction of this court. We are asking you to show where is that execution,
Page
not the name of the party.
Page 64.
Yes.
Last. Auctioning Authority, Senior DCM KGP. And this is the party.
Senior DCM KGP means Kharagpur.
Correct. Which comes under the Southeastern Railway.
So this aspect, where have you have raised this issue?
Yes, my lord, I have raised it. Pleadings, lordship, kindly come to paragraph 20A.
No, before the writ court.
Yes, before the writ court, my lord. That is what I'm.
This is the issue on which it has been rejected. So what have you said before the writ court?
Yes, before the writ court, my lord, I have enclosed. Kindly come to page 45.
45.
Yes. This was before the Honorable Writ Court. Paragraph 20A, my lord has found. Bottom. That your petitioner state that this Honorable High Court at Calcutta has territorial jurisdiction to entertain the present writ application for following reasons stated herein below. E-auction agreement has been executed within the territorial jurisdiction of the Honorable High Court. All controlling and regulating authorities of the Southeastern Railway have their principal seat of office within the territorial jurisdiction of the Honorable High Court. All terms and conditions set out in the e-auction agreement and in the auction catalogue has been framed and stipulated by auction conducting officer, SCO Southeastern Railway headquarters. All authorities of Southeastern Railway has obtained operational clearance, NOC, from Central Railway before inviting bid as per clause 20.3 FM Circular 11 of 2022. Regulating authority here in the present e-auction agreement as per clause 23.3 and 25 of the FM Circular is the Southeastern Railway. Petitioners pays freight charges along with ancillary charges at Howrah Shalimar as per rules and regulations stipulated by Southeastern Railway. Petitioners load and unload business in respect of the said train from Howrah and Shalimar. Impugned Memo 22.5 2024 adversely impacts the settled terms and conditions as entered in between the petition and Southeastern Railway. Impugned Memo 22.5 2024 adversely impacts the settled terms and conditions as entered between the petition Southeastern non-consideration of the representation dated 6/9/2024 by the competent authority at Southeastern Railway. Impugned memo dated 22/5/2024 unilaterally alters, rewrites the settled terms and condition of the auction agreement by increasing the cost component illegally in violation of the Railway Board circular dated 31/3/2022 and 27/3/2024 having a pan-India effect. These all the facts constitutes bundle of facts, thereby constituting integral part of the cause of action which arose within the state of West Bengal. As such, this Honorable High Court has territorial jurisdiction to adjudicate. My lord, I have pleaded all those. Now, my lord, the Honorable Division Bench, in another matter, my lord, similar matter between the same parties.
You are not Mahesh Panjwani.
Yes, my lord, I am the director. Company is the petitioner before you, lord.
This appears to be a different contract. In the judgment, the contract date is 6/10/22.
Yes, that was it. I operate several
Now
parcels.
you are relying upon an agreement of 28/3/23 to give us the cause of action. That is a different
No,
agreement.
may
How
I,
can that draw the cause of action with respect to the other agreement of 6th October 22?
may I say, my lord, I have Southeastern Railway have
Yes.
published auction catalogue in respect of some of the trains
Yes.
which operates from Southeastern Railway to Central Railway.
Maybe whatever it is, this agreement is not the valid agreement which is to be looked into for the purposes of cause of
No,
action.
These agreements,
You are drawing our attention to page 62. That agreement is of 28/3/23,
yes, it's valid for
Whereas-
another 2 years.
whereas the agreement in issue before the writ court is of 6th October 22. Where is that agreement, 6th October 22? Let us see.
6th October 22 was the e-auction agreement in
Correct.
respect
So
of
this is
another writ petition, not in connection with the present writ petition.
The present writ petition is arising out of 17349.
Present writ petition is
This
arising
appeal
out.
is arising out of WPA 17349.
No, my lord, it is 23669.
Then why have you annexed this 134, page 134?
This is in connection with another writ petition which went
Where
to
is
the
the
appeal.
order passed in your writ petition?
Yes, my order passed in page 139.
139.
Yes. This is WPA 23669.
So what is this? The court is yet to arrive at a conclusion and you have already challenged this order. Why have you challenged this order?
Lordship, pardon, I couldn't hear, my lord.
The court has not dismissed your writ on the point of
Yes.
jurisdiction yet. It is just considering the matter. Then you
Because
have- why have you-
because that coordinate bench has already dismissed another matter
so
on the ground
therefore,
of jurisdiction,
so
which
therefore,
went to appeal.
so but there is no decision contrary to the coordinate bench yet.
My lord, I have sought an stay of the impugned operation of the memo,
So
which has been done
actually
by
this
the.
is against an interim order.
Yes, my lord,
This
for
appeal
refuse.
is against an interim order.
Yes.
Yes.
My interim order, my lord, at the division bench has already stayed the operation of the effectiveness of the memo. The same memo I have challenged here. Already that memo has been stayed by the honorable division bench.
Yes.
I have only sought a similar direction from the
In
honorable
this-
single bench.
This order, we do not find the date of the contract. Which contract is to be looked into? This is only referring to a order passed by the senior divisional commercial manager
My
of
lord, the honorable single bench
22/5/24. Where is that
decision.
order? 22/5/24 order. Where is that 22/5/24 order? Which you have challenged in these proceedings.
Yes, I have challenged the order dated 23rd of September 2024.
No. 22/5/24.
22. Impugned memo. That
Yes.
is at page 74. That's what has been stated by the honorable division bench. And it runs contrary to the rules.
How does this apply to you?
I apply because whatever payment I have made, it is agreed upon between me and these parties. They have stated that there will be no escalation. It is there in the agreement. Lordship, kindly see for 1 minute at page 87. And during the midst of the agreement, my lord, this has been issued.
87.
Page 87, my lord, kindly see. Of the policy.
No, you have,
Clause 13.1.
where is the contract? This is the part of the contract.
Yes, it's a part of the contract. 13.1,
Just a minute.
page 87. There shall be no escalation in lump sum lease freight, rent, license fees during the contract period of contracts of initial contract period up to 3 years. Mine is of 2 years. There is no occasion to increase the license fee.
Where is the order awarding the contract to you?
Order awarding.
Yes.
Then my lord, page 62. This is the e-auction agreement. This is the agreement which has been awarded to me. Kindly come to page 63, my lord. The costs have been stipulated. Just at the last paragraph. Whatever I have to pay as per this.
So you have brought parcel space in which parcel van? That is not
In connection with the train which is stipulated here,
where are those trains?
a mode of allotment, e-auction, my lord, the 62.
No, in this.
And train number is written 12102.
Where is that?
That is at previous page 62.
12102.
Yes, 12102, and Roshi will also find the same at the bottom, 12102. And my lord, kindly see
What does SHM mean?
the Shalimar, the abbreviate form.
So therefore, again, we are asking you, how does this circular affect you? This train originates from Shalimar. This escalation is applicable to trains originating from Chhatrapati Shivaji and Lokmanya Tilak.
And also from Shalimar also.
No, it doesn't say so. Let us see.
My lord, it
Come
has
to page 74. No,
74.
it is specific only 2 stations.
Now, my lord, may I say, my lord, it's my respectful submission before this honorable court will be that when an auction intending authority,
Either you are aggrieved by an order or you are not aggrieved by an order. That is the first issue to be seen. There is an agreement which allows you parcel space for a train originating from Shalimar. There is escalation or imposition of a particular requirement in respect of contracts of similar nature operating from CSMT and LTT.
it's not a separate contract, similar contract.
That's what we are saying. Similar contract which is originating from a different station. How can you challenge that?
No, my lord. It's a two-way round trip train. My lord, may I be
Does
clear
not.
to you?
Sorry, it is not. Let us see from the contract. Your contract is
It's
only
a round trip contract.
from SHMT to LTT. That is,
And back. And
where
back.
is that? From where do we get that? The contract does not say so.
My lord, it's a round trip. Round trip means it
Please show. Please show. We want to see it. It has only one train number,
No, my
sir.
lord.
Sir, every train number has 2 train numbers. One is the journey
Yes.
from the originating station to the other, and the other train number is from when it's journey back. Where is that other train?
Yes, lordship, kindly see from page 62.
Yes.
2 numbers have been provided. 12102.
Yes.
Stroke 101.
No, but then
That is going and coming.
But your parcel space is described only with reference to 12102.
My lord, it's a round trip basis.
But we don't find it there.
This is the finding of this honorable court.
Don't find it
This
there.
is the finding of the honorable court, coordinate bench, my lord.
See, we are not looking into the finding with respect to another agreement.
My lord, may I say why I say?
We are only examining your claim with reference to your agreement.
Yes, my lord. For that, my lord, Southeastern Railway has to obtain no objection from the Central Railway before entering an auction stipulating the terms and condition and the cost component. Now, when the Central Railway agrees that yes, okay, that is the stipulated cost, then the tender gets floated and I took part. And before it is nowhere stated that the scanning charges will be imposed. Lordship will also not find from the auction catalog also.
This impugned order of 22/5/24 is not applicable to your train. It is not applicable to your contract.
then in that case, Lordship makes an observation to that extent,
We will. Why not?
because they are charging it. The stand of the
Where
railway,
have you said so? Where have you said, let us see your averment that this is
That is
being
that-
applied, this 22/5/24 is being applied to you?
my lord, I have stated in my writ
Let us
petition.
see. Let us see.
The writ petition starts from page 24. See kindly page 47. It is stated further that in Shalimar, which is coming under the jurisdiction of Southeastern Railway, with whom your petitioner is having an existing agreement, has abstained themselves from imposing any such illegal charges in the form of scanning charges till date, and as such impugned memo has no manner of whatsoever any application to your petitioner's agreement. And thereafter, and before to that,
So this is precisely what we are saying. That it is not being applied here.
but they're applying.
But this is what you have also said. The
They are
paragraph
applying-
that you are just reading, that is what you are saying.
I have also made a prayer before the honorable single bench that this memo has no manner whatsoever any applicability.
But your
they are going to
averment,
be-
you read your averment again, what you have said.
It is
You
stated
say you
further
have
that
filed it to restrain them from applying this to you, but you have never said that they have applied this to you.
I have applied.
So let us see
I
that
have
they
made
have asked
represent-
you to get the
I have
scanning.
made a representation. I have
Whether,
made a representation.
where have you said that
Yes.
you are visited with the effects of this
Kindly come to
impugned?
page 75.
Yes, let us see. What is this?
This is a representation which I have made before the authority that you cannot impose. As per the above referred CPLP, loading and unloading of lease will be done by leaseholder in terms of 34. The leaseholder shall load only such commodities which are permissible to be loaded and carried as per parcel under the prescribed railway rules. As per para 34.4, the leaseholder not allowed to load commodities listed in red tariff, offensive, contraband, dangerous, explosive, and any other commodities which are prohibited by railway or banned by civil authorities. As per instruction from board to the leaseholder, specially mentioned in paragraph 34.5, in case of false declaration of any commodities, the leaseholder and the owner of the parcel service punishable under section 163 of the Indian Railway Act. In such situation, there is a penalty clause available under CLP and even provision for fine of rupees 50,000 on the occasion available in CLP para 34.6, under which leaseholder exempted from scanning of each parcel consignment loaded in this PP due to penalty clause mentioned above. Hence, it is requested in view of the penalty, it is self-explained which allowed leaseholder exempted from scanning only to avoid unnecessary payment to the contractor by the railway. It is also requested due to exemption of scanning, the wagon turnaround will also be unaffected and also save labor cost engaged in loading and unloading.
There is no reference even to this impugned.
My lord, kindly come to the next representation. That will clear everything, my lord. Page 118.
100,
18.
180.
118. Yes, your undersigned is currently engaged with the Southeastern Railway for leasement operation under contract number com such and such dated 28/3/2023. Your undersigned is a leaseholder for the loading and unloading of leased PP for the assigned train number 12102. Despite adherence to all existing regulations pertaining to leaseholder, the Railway Authority has recently introduced a new regulation dated 22/5/2024 issued from the Office of ACM Goods Mumbai Division, which requires leaseholders to pay an additional ₹2 package for security screening charges to ensure the safety of the Indian Railways. Your undersigned believes that this additional cost should be borne by the Indian Railways as an extra security measure to prevent unforeseen incidents. It is perplexing that the railway has passed this entire charge on to your undersigned despite your undersigned compliance in declaring their loading and unloading details in the provided manifest with other regulatory mechanism in place and payment of advance freight charges as per e-auction table. Furthermore, as per your undersigned contract with the Indian Railways, your undersigned has consistently paid all stipulated costs without fail. It is therefore unlawful and unjust for the Indian Railways to impose additional charges beyond the terms of your undersigned existing contract, causing us to incur irrelevant expenses. My lord, kindly mark this. It is also important to note that the aforementioned scanning charges are not collected directly by the Indian Railways. Instead, these fees was directed to be paid to a third-party vendor engaged by the Indian Railways without prior notification to the holders. The rates set by the vendors have been fixed by the Indian Railways. Your leaseholders to incur these costs without any wrongdoing on your undersigned's part. It is stated further that the impugned letter dated 22/5/2024 has been issued in contravention to clause 4 and 6 of the Railway Board Circular 31/3/2022. And for clarity, clause 6 of the Railway Board Circular is reproduced herein below. For leased parcel space, the leaseholder may have the facility of scanning at their depot and affix seal stamp tag on packages after scanning, which shall be cross-checked before loading. Alternatively, the leaseholder may use the facility provided at the station for scanning of the consignments. The responsibility of genuineness of such consignments bore with the leaseholder and violation of any penal section of criminal law in force may also result in the prosecution under the concerned criminal act. From the aforesaid clause 6 of the Railway Board Circular dated 31/3/2022, it will clearly appear that the usage of railway scanning facility is optional and not mandatory. Moreover, scanning can be done from leaseholder's end also, which may subject to cross-checking by the railway authorities. However, impugned letter dated 22/5/2024 has been issued in violation to Railway Board Circular dated 31/3/2022, rendering utilization of scanning facilities at railway station mandatory, subject to payment of cost to be paid not to the railway administration, but to a private contractor with whom there is no contract with your undersigned. It is stated further that your undersigned executed a lease agreement with South Eastern Railway, being the tender issuing authority and a signatory to the e-auction agreement with the prescribed conditions of payment, which is reproduced herein below. My lord, contractors will be liable to pay development charges, 2% license fee, leasing charges plus GST as applicable for this lot. These charges will be applicable over and above the license fee, license charges as specified in the contract. Other charges as mentioned in the lot details or asset details shall also be borne by the contractor. The contract value shown above does not include the escalation amount applicable from the 4th year onwards. The escalation amount shall be over and above the contract value. From the aforesaid stipulation, it can be clearly ascertained that imposition of cost for scanning is beyond the domain and purview of the e-auction agreement, as the same has an effect of imposition of unilateral clauses, much to the prejudice to your undersigned, and has an effect of rewriting agreement which is illegal and diverts the provision of the statute and that of the circular. As such, no other payment under any head can be imposed upon except what is stated above during the currency of the contract, and South Eastern Railway being the controlling authority, my
What
lord.
is the stage before the Honorable Single Judge? Now they have filed their affidavits
Nothing has been filed.
on 23/9/24.
They have not filed. Only
After that, what has happened?
after that, my lord, I sought for a stay of the impugned memo in terms of the Honorable Division Bench's order. Honorable Single judge was of the opinion that till the decision is being taken or finalized in respect of the jurisdiction point, he will not going to hear this matter further.
Yes, so thereafter what happened?
Thereafter, my lord, I filed this
They
appeal.
must have filed their opposition.
Nothing has been filed from their end.
Let it be decided then by
It has to be decided, my lord.
the Honorable Single Judge.
My lord, that
Because
Honorable
see, you are, from this representation, we do find that you are being affected by the,
yes,
but it is not the circular itself which offends you. From your representation, it appears that it is being implemented by the authorities arbitrarily.
Yes.
It is not the circular itself which offends
my
you.
lord,
Because they are charging it at the destination point,
and
which is
when-
contrary to the terms of the
when
circular
I-
itself.
yes, when I loading the materials at the destination for the originating, then also they are charging.
No, that is not there in your representation, sir.
My lord, I
that
have
is
not
not there.
completed the entire thing.
We have seen it. We have read it. That is
But-
not there.
But my lord, whatever
What you are saying is when it reaches the CSTM,
my lord, they have
then they charge it
not
at the
only
landing point.
not only they charge that.
But we
In
don't
addition to that,
don't see that from your.
in addition to that,
We don't see that, sir. Please point out from this where you have said.
My
You
lord,
come to page 120, paragraph 4.
moreover, your undersigned has an agreement with senior divisional commercial manager under the jurisdiction of Southeastern Railway. However, when your undersigned parcels reaches the CSTM Mumbai, the competent authority imposes additional scanning charges to your
Correct.
undersigned.
This is
This
your
practice is not only incomprehensible
correct.
and unacceptable, but also against the established rules.
So it is not the circular which is offending you, it is the arbitrary action of some authority who is situated in CSTM.
My lord, may I say this? Thereafter, this practice is this process of harassment does not end here.
Yes.
After paying the additional imposed scanning fee, the entire procedure takes an extended period. Yet
Yes.
a time frame allotted by the railway for loading and unloading remains unchanged.
Correct. So you are being affected by that charge which they are levying at the landing point. It is delaying things and therefore you are suffering.
And also during the loading point,
that you
I
don't
have
see.
stated.
That you don't.
Here I have stated for
Okay.
loading and unloading. Unloading means I unloading the consignment,
And
and
by inference, we don't find it.
this is. But thereafter,
We don't find it to infer such a case.
but my lord,
If that had been your case, you would have said so very emphatically.
In
Like
fact-
you have said about the landing point, you would have said that we are being levied with the same.
now my lord, I have made
And-
this representation because I have an understanding
Your
with
represent-
Southeastern Railway.
So your representation is very clear. Your client is very clear in what he is agreed by. He says, look, we have entered into an agreement. We are liable to pay certain charges. We pay those charges. We put the goods in the train. When it reaches there, they ask us to pay more in. Now that is not in terms of the circular. So the circular has nothing to do with this.
But-
This may be an arbitrary action of the authority there.
My
It's
lord,
not the circular.
here I have made this representation also. Kindly see to whom. Kindly see.
Whoever it may be,
It is to the tender issuing authority
whoever it may be,
because tender.
that will not make the circular applicable.
But the circular is against this policy of the railways.
It is not affecting you. You cannot challenge it.
My lord, they are taking these charges from me each and every now and then.
See, your representation is clear.
I have made my representation clear, and also, my lord, from the
Not
abandonment.
your case that you are affected by the circular. Your case, as per this representation, is clearly stated by your client that look, there is a charge which is being levied at the landing point.
And is
That is delaying our loading, unloading process and everything. And therefore, we are suffering. And this is a charge which we are not
Now, my
liable
lord,
to pay.
my lord has seen from the e-auction agreement
Yes.
that there are two numbers, 12102,
But we have seen that-
12101.
Yes.
So I am paying freight. Lordship will certainly inquire from them.
Sir, only when you make out a case, we'll ask them. Therefore, we are trying to see. We want to see in black and white that this contract is for both up and down trains. Secondly, that it is being levied at the loading point on the reverse journey.
Yes, it is my point.
But we don't
But
find it.
railway, let them.
Unless you say so, what will be the ask? Will we
May I
ask them
say,
to say?
may I say, my lord? May I say, I have
That is your specific case, then you should bring that material on record. Otherwise, why should we call upon them?
now, my lord, I have
It is being considered by the honorable single judge. She will examine it or he will examine it.
now, my lord, in the writ application before the honorable single bench.
What is your instruction?
Not briefed in this matter.
Who is appearing?
Sonojit Kumar Ghosh.
Ask him to be here. Why he is not here?
He's unable to come to court for this entire week due to illness, my lord.
Huh?
He's unable to come to court for this entire week due to illness, my lord.
Entire week he'll
This
be ill.
matter, we need after this week.
Next week, my lord.
Let it come on Monday. If you want to file any supplementary, you can do
I
so.
will.
Please understand what
I
we
have
are.
understood. I have what has fallen from your lordship. I have understood
You show that, then there nothing remains.
because at present, my lord,
All are same.
all are same, all are analogous.
It is submitted.
সপ্তর্ষি রয়।
You are appearing in these matters. Then no, please, not right now. Please, not in the midst of court proceedings. Next,
Item number 2,
you know better what is the time to mention. Don't At the time of rising, you may mention. Until now, we don't. I mean, no, this is 1 to 4 is Monday. 1 to 4. All cases have separate orders. Separate order.
Item number 5.
My lord, service is incomplete. Service is incomplete. So, my lord, is an honor interpretation. Regarding the compensation for apartment, my lord.
Continue. The order is challenged also before the tribunal. Tribunal therefore I filed the contempt application. Contempt disclosed. Supposed to MFC, he is appeared in the tribunal, but no any objection, given any objection. He is not recused. He will not give any LOC. How recused give the LOC.
And even if she gives NOC, you will not get the employment because you have not given the relevant material regarding the financial hardship. What can be done?
Their notification has not any detail. Mandatory,
No, that is referred employee 251.
251, then no mandatory.
Where is 251? Let us see.
Why not kind of about take time and I give the.
No, give us. Where is 251?
It is appeared on 30th November, but unfortunately it is appeared 4.
Huh?
I am direction to the clerk, it is appeared on 30th November, but unfortunately it is appeared 4.
Tomorrow, come with the AMP 251 tomorrow, not today.
My lord, my lord,
AMP
2 weeks
251.
time.
Sorry, tomorrow. Unnecessary pending.
I am
Tomorrow,
not
sir,
connected.
tomorrow.
My lord, it is unable to
We
correct
just
the.
want to see AMP 251. Nothing else. Come with it.
Item number 6. 6, I am for the petitioner, my lord. That the service not completed since, my lord, the GP office was closed. So I am paying, my lord, let it be next Monday, my lord, that is something.
What is the
Service,
system?
what happened?
What is the system of service? We are just
What happened, my lord? I filed on 7th. And that time GP office is closed because the state government is closed. And today also state GP office is closed.
so it has to be served in the office.
Office, my lord, GP office.
Then the brief will be allotted to someone and then he will
Yes,
come.
sir.
We are just trying to
But
understand what is
also
the system. What is the system?
My lord, we have to file 1 copy, 2 copies in GP office. They will engage one advocate. And if I service to the respondent, they will not engage any.
No, that is normal. You serve
Yeah.
it on the AG office or GP office, wherever you
GP
serve it.
office, my lord, they will engage an advocate.
And then they will appoint a counsel to
And I
assist.
filed on 7th that is, my lord, state government is closed. And today also state government is closed.
Closed. Why?
Extension of Bhaifota, my lord. Bhaiduj. That's all Bhaiduj. Extension of Bhaiduj.
So when do you want it?
Monday?
Monday as per-
Monday.
Monday under the same heading.
Item number 7.
Well, advocate record is due to his illness, he cannot come to court. I'm praying for a week adjournment for.
On account of the learned
Item number 8.
My lords.
My lord, from item number 8 to 27, my lord, Mr. Orpo Chakraborty is appearing on behalf of the petitioner, my lord. There has been a very unfortunate bereavement in the family, my lord. I was humbly praying for one day accommodations, my lords.
What are all these matters? Do you know?
My lord, I'm not in possession of any
You are
instruction.
for the respondent. What is the issue?
2 points, my lord. The actual workers, they were disengaged and they have
Disengaged as?
and one more below the regulation of the casual.
No, they have been disengaged from which service? From
2019, they have been disengaged because the already if it is if we adopt the point taken in the respondent by the tribunal, it will be clear. The long judgment is there,
no, what is the issue? We just want to know what is the petitioners are
not completed 10 years.
okay.
Just
As
against the rules.
not completed 10 years on a daily wages.
Yes.
Oh, they are seeking regularization.
No, they have not regularized because to regularize the certain
They are seeking regularization.
regulation. And they should be taken up.
See, we has asked for adjournment. We are not refusing the adjournment. We want to know what is the issue. What is the issue?
Issue is that, my lord, that they have been working continuously for 16 years, not
Okay.
daily basis.
Okay.
And thereafter, my lord, what happens?
As-
They paid as, my lord, contractual staffs. And, my lord,
In which establishment?
Doordarshan. As different musicians, they're musicians, my. So, my lord, what happens after that, my lord? They paid for regularization that was pending. And in this meantime, my lord, they have, my lord, taken a decision that they will be replaced by some other contractuals.
Oh, one set of contractual employees. Okay. Tomorrow, you want tomorrow?
Only, my lord, because the learned advocate on record, my lord, is just
Very well.
in this position.
It is submitted.
So sorry, my lord, because these are series of matters, my lord, from item number 8 to item number
25.
We have understood 8 to 27.
yes.
Please give a appearance.
Yes. Appearance to 26.
8 to 27. Similar order.
But the entire brief actually went live with him. Otherwise, I would have not placed it. Great.
We are relying upon some judgment.
Yes, my lord.
Series of judgment, that's right.
The proposition as followed from your lord. So,
Yes, all right.
great.
Item number 28.
That's the point. None appears on behalf of the there is very thin appearance.
Oh. Item number 29.
Is the same order. Some means things I can't understand. Don't have these things. Or after this.
Item number 30.
All these are Union of India matters. Same order. Same order. You are appearing in 30.
Item number 31.
You want? Funny. 68. Or held it. State government extended holiday applies to all. Lordship. Lordship, I'm praying for short passover. My senior is on his legs. You are for the petitioner. Should be this side. Affidavit in opposition has been filed by the state.
Yes. 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 We have received, Lord.
Lordship, in this matter, I'm appearing for the state, Your Lordship, led by Advocate Sonal Sinha, ma'am, Your Lordship. I'm praying for not this week, Your Lordship.
Why?
Oh.
Your Lordship, my senior has not come and she has asked me to pray for
You are here, we'll see. Every matter is being adjourned since morning. Why? High Court has already opened. Why everybody is absent for an extra week?
Lord, there are two more respondents. One is Lord, AG Bengal, that is Lord, Accountant General West Bengal.
Pay and
And-
accounts.
Yes, pay and accounts.
Yes.
And another respondent, that is private respondent, because Lord, I have, in fact, Lord, I challenged the order of the tribunal.
You had approached the tribunal.
No. In fact, the respondent, the private respondent
For?
had formed retirement benefits due and payable to the minor son of the second wife. Minor son approached the tribunal, being represented by his mother. But he is the minor.
Was the sole claimant or he was seeking apportionment?
No, he was seeking retirement benefits, which was due and payable to the deceased husband.
So we are
Lord,
asking
he
if
was
he was the sole claimant or he was seeking apportionment of a portion of the retirement.
portion. Lord, my grievance was limited to the extent that he is definitely, even if he is a minor child of the second wife, but he is definitely entitled to the gratuity and other benefits.
Then
50%.
What the tribunal has held.
But tribunal has held that he is also entitled to 50% pension. That is my cause of grievance, Lord. He cannot, Lord, as per rule, Lord, he cannot claim the pension. He is definitely entitled to get the 50% amount from the gratuity, which Lord,
Tribunal
I being the first wife, I am entitled to 50% gratuity. He is the minor son of the second wife. He is also entitled.
Gratuity is to be a portion 50-50,
50-50.
but pension is not to be a portion.
Pension that is the only issue to be decided by your lordship. Whether pension can at all be granted to the minor son of the second wife. That is the only issue. As per rule,
You said the pension has not been granted to you.
family pension cannot be granted to the second to the minor son of the second wife. That is my whole.
What has the tribunal held?
Tribunal has held. Kindly have a look to the order. No, order. Yes. The impugned order is at the last annex, sir. The order is dated 12th June 2024. Certain notifications have been taken into account by the impugned order, which was relied upon by the learned tribunal.
Please allow us to go through the order.
Yes. Affidavit gives you, no? No. It's account. এইটা সবথেকে ইম্পর্টেন্ট কোন প্যারাগ্রাফে Teacher opposition. State to file for him. देखिए फाइल opposition side को
Yes.
No, my lord, your lordship has seen, my lord, the tribunal, in my respectful submission, my lord, has misinterpreted the notification and the rules. Because, my lord, if your lordship kindly takes trouble to see the affidavit filed by the AG Bengal, my lord,
You have served a copy. You are for the state. What the accountant general will say, we have to examine the rule.
rule, right. No,
The rule, let us
well,
see.
that has been annexed in the
There
affidavit.
is rule 7.2 and there is rule 7E1. 7.2 you say applies to pension. E1 you say applies to gratuity. Gratuity, there is the son of the illegitimate son is also included.
Right,
In pension, it is not.
right.
Subsequently, by an 88 notification and 97 notification, the issue has been clarified. What does the accountant
So
general
that
have to say?
clarification, my lord, also does not apply in.
Let us see what will the accountant general say about it.
Yes. Now, my lord, your lordship kindly have a look. The relevant rule is annexed to the opposition filed by the accountant general,
Yes, please.
appearing at page 5. Relevant जाएगा तो. Now, kindly see 105 at middle.
At 105.
105, rule 105 at middle portion.
Just a minute.
At page
Accountant
5.
general is respond number
4 and 5.
which you have filed today. Page 5.
Page 5, middle portion, my lord. Rule 105.
Yes.
The pension payable to one member.
What is this? What is this?
This is the death cum retirement benefit rules.
ECRG rules.
Yes. Kindly see, my lord, 105. Pension payable to
What is the date of this rule?
1971.
71.
Yes.
So it is this rule which has been clarified
Yes,
by the
yes,
two
yes,
notifications.
yes, yes.
And where are the clarifications?
Lord, clarification, Lord, just a minute. That is also there, Lord.
In the same affidavit.
Yes, in the same affidavit. Notification at page 7 of 97.
And 88 one, where is the 88 one? There is one of 88 and there is one of 97.
97, Lord, has been annexed in the affidavit.
13 January 97.
Yes.
And there is one of 29 July 88. July 88 is there. 26. Hmm? 10 of this same affidavit. Where do we get the date of this? 26/7/24. This is 24. Huh? Sir, please come to the tribunal's order. Page 3. There is a finance department notification of 29/7/88 and another notification of 13 January 97. These two have been considered by the tribunal.
Yes, yes.
So where are these two? That is what we are asking you. One you have already shown at page 5. Where is this 29 July 88? So let us see. It must be there in some book.
97.
Obviously, it was before the tribunal because tribunal has considered it. Is it part of the writ petition?
Let me just.
In fact, it has been quoted in the order.
That's correct.
So why can't we rely on that quotation? Are you saying that is misquoted?
Just a minute. Let me take the application. But the petition is petition 80, 97 is there, but 88 is not. It should have been annexed. Let me just check it. এদের affidavit আছে কিনা দেখ না। ওদের affidavit, সায়নের affidavitটাই দেখ, সায়নের affidavit। এইটা এইটা দেখছি না। নেই, থাকবে তো। এখানে রেফার্ড হয়েছে অর্ডারে। থাকার কথা। In fact, the 88 notification was never produced by any of the parties, but tribunal relied.
It has been quoted in
That's
the,
correct. No, tribunal relied.
has been quoted in the order.
That's correct. No, I have seen that.
Yes.
I have seen that. So, if your lordship directs the
Why should we direct? You don't, you rely on the quotation. It is not your case that it has been misquoted. The quotation is there, let us rely on the quotation. Unless it is your case that it has been misquoted. That is not your case.
no, it has not been misquoted.
Then let us
Yes.
see what it says.
Yes.
We can rely on that.
Finally, আপনার কথা আমি দেখেছিলাম দুটো নোটিফিকেশন হলো। পেজ কত? দেখেছি ওটা আমি। হুম অ্যাপ্লাই করে না সেটাই বলছি। হুম হুম My lord has seen, Lord, possibly the relevant portion of the notification of 88 has been quoted in the order.
Yes.
And Lord, the subsequent notification of 97, that has also been quoted. Lord, from the two notifications of the Lord, clarification of the rule, Lord, it appears, Lord, in absence of the second wife, the minor child would be entitled. But in presence of the, your lordship, kindly have a look. This has been possibly misinterpreted by the tribunal. Yes. Not at all. Right. এইটাই তো বলছি, এইটুকু একটি কপি আছে। I'm sorry, I have got one copy of 1988 notification. Right. Good.
Oh, this 88 sub, you have a copy.
Yes, Lord.
You have a copy with you.
Which one?
Yes, you are having a copy.
No, Lord. That is the only
Only
copy.
one copy.
Lord, I have just found out from my file, Lord. Only one copy.
Xerox निकल Xerox निकल Xerox हो जाएगा नहीं इसमें नहीं है ये प्रिंटर में नहीं है because see it says the child born out of the another second marriage
Yes.
for the purposes of 7E1, 1 and 2 all, not only 7E1. If it was 7E1, then what you are saying perhaps may have been correct, that only for the purposes of gratuity. But it says they will be deemed to be children, legitimate children for the purposes of the claim under 7E1 within bracket 1 within bracket 2, and 2 is the pension.
Now, Lord, further clarification has been made in 1997.
All right.
Yes, Your Lord, you kindly have a
Now come to that.
yes. By another notification published on 13 January 97 of the Finance Department, few amendments were made to Rule 104. West Bengal DCRB Rules 1971 was made. Copy the copy.
Yes, that
No.
we have at page 5 of his brief,
Yes.
of his affidavit.
Yes.
That is at page, sorry,
Yes.
page 9. No, you have annexed it. You have annexed it. You have also annexed it. 97 one you have annexed.
Yes.
It is at page 9. Note. Where is the note? Page 8.
Page 8.
Page 8. Second line from the top.
Yes.
That has been quoted in the order.
Yes, that has been quoted.
Is it?
Yes.
Yes. Where the, please read, Mr.
Yes. Now, Lord, in the Your Lordship sees, Lord, Lord, kindly see II. That is relevant too.
Yes, yes.
Where the deceased government servant or pensioner is survived by a widow but has left behind eligible child or children by another wife who is not alive. Who is not alive. Kindly see, Lord. The eligible child or children shall be entitled to the share of the family pension which the mother would have received if she had been alive at the time of the death of the government servant or pensioner, provided that on the share or shares of the family pension payable to such child or children or to a widow or widows ceasing to be payable, such share or share shall not lapse, but shall be payable to the other widow or widows and or the other child or children otherwise eligible in equal shares, or if there is only one widow or child, in full to such widow or child. So this has been further clarified. 88 has been further clarified. Well, had the case been like this, what that second wife had given birth to a child, he or she is a minor, and second wife is no more in the world. In that case, what the child would have been entitled. Right.
Give us 2 minutes.
97, Lord, your Lordship has seen, since Lord, after 88, 97 notification was published, Lord, that has clarified the entire thing. Now, Lord, my humble submission would be before your Lordship. Yes, because Lord, the second wife has to qualify for pension first. If she qualifies for pension, only in that case, Lord, if the second marriage is valid, because after termination of first marriage, if the second marriage takes place, then the second marriage is valid. So, since the second marriage was not valid marriage, the child might be legitimate, but the second marriage was void. Therefore, she did not qualify for pension. Since she did not qualify for pension, the son cannot get the pension. That is my whole case. Family pension should be disbursed to the first wife who is surviving.
Lordship, I am for the private respondent. The minor child.
I am not aggrieved by the other portion of the order that 50% gratuity amount should go to the child. But there I cannot stand in the way. He is definitely entitled to get it. ওই যেটা ট্রাইব্যুনাল করেছেন না, এখানে দুটো নোটিফিকেশন, ক্লারিফিকেশন নোটিফিকেশন যেটা ট্রাইব্যুনাল অর্ডারে, একটা 88, একটা 97, দুটো নোটিফিকেশন রিলাই করেছে ট্রাইব্যুনাল, ওইগুলি চাইছিলেন জজ। Yes. '97, because further clarification has been made. But the relevant part who would be entitled, that has been clarified. Because it is a subsequent clarification, that should, yes, yes. 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 না, আমরা তো আগেই জমা করে দিয়েছিলাম। Page 5 of the affidavit filed by 4 and 5. ওই অ্যাকাউন্টিং।
এটা কি আজকে জমা করেছে?
না না, অ্যাকাউন্টিং।
Lordship, may I have a copy? I don't have any copy. The affidavit which is.
এটা আগেই দিয়েছি।
I am for the minor child, Lordship, represented by a mother, his mother.
Also, এটা তো incomplete, এটা incomplete. But, my lords,
Lordship, the DCRB rules.
DCRB rule,
I have one xerox.
relevant জায়গাটা কিন্তু relevant জায়গাটা দরকার।
Page number 43 and 44.
And 105 also. 105? না, ও তো জেরক্স করে রেখেছে। যার হোক নিয়ে নে না, দরকার আছে বলছে এটা ডিসিআরবি। এই দিকে আমাকে একটু সাপোর্টই করেছে বলে মনে হচ্ছে। এই যে yes, that is my whole case. But he is definitely entitled to 50% gratuity. There I am not aggrieved. Yes. Yes. That part of the tribunal order is all right. Yes. 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 Okay. No.
Yes.
Yes.
Lordship, Accountant General declared me as an illegitimate child. In the affidavit which has been filed by the applicant, I have said that I'm illegitimate child. And for that, 22 lakhs has been disbursed. Yes, Lordship, yes. I bow down.
Lord, Lord, But in the affidavit filed by the private respondent, the relevant rules have been annexed. The entire rule, 4, 5, everything is there. But if your lordship takes up his affidavit, your lordship would get it. Page 16 is the relevant part. Respondent number?
Yes, Lordship.
Yes. Page 16.
Yes.
The rule starts from page 12, relevant portion 103, 104. Yes. Yes. Which one? Yes. However, under section T61 of the said fact, though the second marriage is null and void, any children born out of such second marriage shall be legitimate, and such children are accepted as members of the family, legal heirs within the meaning of yes. That needed the clarification. This is of 71. Your lordship, kindly have a look to this. This is of 71 rule. That needed clarification. That's why the finance department, Lord, by bringing the amendment under 309, Lord, has clarified the situation. So now the entire case should be confined to 97 notification. Yes.
Ship, that was not the case by the appellant in the whole petition. Yes. Yes.
Yes. Yes. Yes. Yes. Absolutely. Absolutely. Because the chapter regarding pension has been clarified. Other portions, he is definitely entitled. But right. Yes. Yes. '97 notification, Lord, is just a minute. Yes. Lord, the date 13th January 97. 13th January. Minor
Second wife nor children of the second wife are entitled.
is entitled to pension, family pension.
Yes. Gratuity and pension have been defined. Under this rule, the gratuity and pension must have been defined.
My lord, in 1971 rules, my lord, I have to check, my lord, the relevant part.
Where is the definition?
A lot.
They are separate or they are in any way have to be identified together.
Index number power. Index.
Normally it says pension includes gratuity. This is the normal definition in any rule.
Yes.
So is it a separate? What is the definition here? In which provision? Definition note 2. Note 2F. Pension except when the term pension is used in contract includes gratuity.
Hmm. 97, 8. 97. Exactly, 97 plus. 8 and 8 and language.
This is a modified. Yes, and what is your case? Who is for the state? You want to hear the state first? Yes, what is your case?
Lordship, we were supposed to file affidavit, Your Lordship. The affidavit has been gone for the affirmations, Your Lordship. I'll be getting after this week, Your Lordship.
You filed an affidavit before the tribunal.
Uh,
You must have filed opposition before the tribunal.
no, High Court is, Your Lordship. I'll be filing an affidavit in the High Court only, Your Lordship.
That we have understood. What we are saying is you might be taking the same stand.
Yes,
What was your stand before the tribunal?
Your Lordship, I have been instructed to say this only, Your Lordship. My senior has not has left the court, Your Lordship, and I am.
Said your
I have
senior
been-
is not here. You didn't say that your affidavit is not on record. We were under the impression that pleading is complete. Therefore, we proceeded. You said your senior is not here, so we said we'll hear you. Don't worry. Anyway, what is your stand? Yes, Mister.
His Lordship, in my affidavit, which I have filed before this court, I have annexed the relevant DCRB rules, which clearly shows, Lordship, as this court points out that section T61 from page number 17, Lordship, and another two reported judgment of the Supreme Court that has also been annexed with the affidavit, Lordship.
Interpreting the same rule.
Yes, Lordship.
This very rule.
Yes. The rule is, Lordship, the children from the second wife is entitled to get the family pension.
We are asking you, it is interpreting this very rule or it is dealing with the issue regarding eligibility of a son
No, not eligibility of son. Regarding the family pension of the children of second wife.
Correct. So it is dealing with that or dealing with this provision that we are considering. This provision fell for consideration before the Supreme Court.
Yes, Lordship.
Let us see where is the quotation of this
Yes,
provision.
Lordship. Kindly come to page number 20. That is 20, 15, 14 Supreme Court cases 511.
Page number.
Page number 20 of my affidavit, Lordship. That is one. Raj Kumari and another versus Krishna and others. And other Lordship, page number 24. Rameshwari Devi versus State of Bihar and others.
We are
2002
asking you
Supreme
whether
Court.
this rule has been considered. You are referring to a case of Bihar. How can this rule be applicable in Bihar?
No, not this. This
We
rule,
are
Lordship.
asking you whether this rule fell for
No,
consideration.
no,
You said
not
yes.
this DCRB rules,
Then
Lordship.
don't say yes. You said yes. Say
That's
that
my
a
mistake,
different-
Lordship.
It may be, you may be saying it is similar, or you may be saying that the law will apply here.
The law,
We are asking you whether this rule was considered or not.
not this rule, but the
Then we have
ratio
to
is applicable here.
That is a different thing. This rule was not considered. Any other, this rule, if this notification is of 97, by now it has not been dealt with by any division bench.
Lordship, I have just received these 97 rules from now. Just here. And Lordship, another thing, the
Will serve a copy today. You said your affidavit is being prepared.
No, Your Lordship, it has gone for the affirmation to the department. Your
How
Lordship.
long it will take?
Your
Indefinite.
Lordship, after this, 1 week it will be taken.
Yes, you ensure that it is done within a week.
Your Lordship.
The pure question of law, what stand you will take? We have to consider the rule and its purport.
So, Your Lordship, I'll be filing this week only, Your Lordship.
Yes, take.
Lordship, another thing, Lordship, the GPF and the leave salary. The earlier bench heard the matter and asked a affidavit from the appellant that how much money and what is the exact amount which they have received. Lordship, they have already received 22 lakhs. Now, my case is I am also entitled to get the half of it, the GPF and Lordship, the leave salary. They have said the death gratuity, group insurance I have received, but my submission before, respectful submission before this bench's Lordship,
So we
that
are
I am
considering it, we'll consider the
his Lordship.
learned counsel for the state. Tuesday.
Grateful.
I'm grateful to my Lord.
Up to date. 597, up to date. Latest, yes. Ask them to get new one if they don't have things. If they don't have, ask them to get new one.
Item number 32.
Yes, my lord. I'm the British. I'm in person, my lord. Yes, Mahadev. My lord, is a case for the dual charge allowance. Now it is additional post allowance, my lord. I was a senior law officer at Eastern Railway in the year 2018, my lord. And thereafter, my lord, there was a three post of senior railway in Eastern Railway, my lord. I was the senior railway headquarter, and there was a specific post of senior railway arbitration in the office of general manager Eastern Railway, Fairly Place. And my office was Eastern Railway in the New Kailagata, my lord. But after the retirement of this then senior railway arbitration, my lord, Mr. Gaur Haridas, there was a vacant post was there. And after 1 month, on 29/6/2018, my lord, I was ordered to look after the charge of the post of senior railway. But in the order, my lord, at page senior railway arbitration, never it was a post of law officer arbitration. But in the order, my lord, page number page number 18, my lord. Yes, reply.
Affidavits have been filed already.
Evidence is filed and the only supplementary reply is filed of the reply filed by the railway before the tribunal has been annexed. It has been also annexed by supplementary affidavit, my page 18, my lord. Page 18. First, I look after the charge. I was ordered to be look after the
1/8.
Huh?
18/1/8.
1/8. 1/8. And thereafter, page number 24. 24, my lord. Page 24. Look after the duties of senior law of arbitration. And Sri A.K. Srivastav, law officer. Again, my lord, page number 29.
So there are many occasions on which
2-3 occasions I've used. My lord, initially I was taken the charge of 29/6/2018, and thereafter, my lord, page number 25, the general manager Eastern Railway has sanctioned the dual charge allowance. Page number 25, my lord.
charge allowance is payable under which rule?
Yes.
The dual charge allowance is payable under which rule?
Rate. The rule is here, my lord. 19, page number 20. 20A.
Page number?
Page number 20 is look. DOPT circular is there, my
28.
20. And the type copy is 20A. And para 3B, an employee formally appointed to hold full charge of the duties of the post of on similar level as his own post and addition of the duties of the own post will be entitled to draw 10% of his present basic pay for month of additional post and allowance and last in para 3, my lord, the allowance will be admissible only after the duration of additional charge 45 days, my lord.
So according to you, it has exceeded 45 days.
Yes.
It has exceeded 45 days.
Yes, 45 days I have applied.
Where have you given the periods?
Period. My period, I was 17 months continuously. I was taken the charge, 17 months. That is very surprising, my lord. And page number 21A. 21A, my lord. Para 3C. this arrangement cannot continue for a particular vacant post for more than 1 year and for the particular employee for more than 6 months at a stretch. In addition, there shall be minimum gap of 1 year. My lord, no gap was there, my lord. Continuously 70 months, I was forced to take the charge, my lord. That is repeatedly I applied that the post is to be to appointed senior LO, and otherwise it is very difficult for me. And several appeal has been preferred, my lord.
Para 6.
So this additional charge that you are holding
Yes.
of of law officer arbitration.
No. Law office, that was no post of law officer arbitration, senior LO. One subsequently to page number 24, that is senior LO. And in that law officer has been, the nomenclature has been given in the law officer to avoiding the dual charge, giving dual charge amount. But even my lord, page number 25, the general manager has sanctioned the same. 25, my lord. In terms of the office order, such and such, Sri Mahadev Ghosh, his senior LO, was temporarily detailed to look after the duties of the vacant post of arbitration, in addition to his own stating therein that the said arrangement does not attract the provisions of any dual charge additional allowance. As approved by the competent authority, it has now been decided that the above mentioned arrangement will be treated as dual charge arrangement for grant of additional post with effect on 25/1/19, my lord. That was the order of the general manager. Even after that, the dual charge allowance has not been paid to me, my lord.
So for the first period, they have denied it. For the second period, they have allowed.
No, second period for the limited period, my lord.
They have given it, they have allowed the allowance with effect from 25/1/19.
19,
Whereas your first additional charge was
to
June
296 2018.
That was before.
Yeah, after 45 days, I have to apply, my lord. That was the rule. And after 3 months, I have applied, and the general manager has sanctioned. But subsequently, that has been allowed.
Sanctioned with effect from a particular date only.
Yes, yes, sir.
25/1/19 to 18/11/19.
Yes. Even after that, the nothing has been paid to me, my lord. That is my grievance. But what is their reason, my lord? Their plea, the law post was the law officer.
You are claiming only the amount as admissible under Annexure A5.
Yes.
Then why you are not paying this amount?
After
No, he is confining his.
What is
prayer to
admitted?
I'm placing lot.
Admittedly, I was taken the charge, my lord.
You are confining your claim to Annexure A5.
My stand, my lord, is
F,
Page 25.
page 25. 25, page 25.
You are confining your claim to this
Yes.
benefit. Yes.
Yes.
Why?
Your logically says. Page 20A. That is the just my different place you have.
Huh?
Paragraph 6 was not placed. Your logically says. Paragraph 6. Additional post allowance will
If
not
it is
be-
a lower post, he will not get. That is
Not-
what you are
he is
saying.
not entitled.
But
Then your lordship, my lord, what I have stand, my lord, your lordshipally says the supplementary.
have you withdrawn this order of the principal
By
chief personnel officer?
not entitled to get the benefit. Your logically sees the rule. Your logically sees.
Have you withdrawn this order of the principal chief personnel officer at page 25?
45.
Page 25 is an order, office order. This order has been withdrawn.
No.
Then why he will not get the amount?
Because, my lord, by mistake that has been your logically sees.
17 months.
Very well. Very well.
Then your logically says what is the rule?
Yes.
Some page your logically says that the dual charge has been abolished. Dual charge has been
That is,
abolished.
my lord. The nomenclature has been changed.
Now your logically says the page 18.
Dual charge has not been abolished, sir. Dual charge is not
Nomenclature has been changed.
admissible if the dual charge is held of a lower post.
Lower post.
It has not been abolished. It is not admissible only if it.
Because your logically says your
Nomenclature has been changed.
18.
18 of the supplementary affidavit.
Supplementary.
Supplementary affidavit, my lord, they have filed the reply to the tribunal.
Page 18.
Page 18. And placing this your logically see. That will clarify. Recommendation has been made by the 7th Central Pay Commission in report of abolition of the dual charge this year, recovering such and such, covering the additional repay. The number paragraph 2. the recommendation was under consideration of the committee allowance and such as Ministry of Finance, where the resolution 6/067/2007 had accepted the recommendation of the committee on allowance regarding the abolition of the DCA, stands for dual charges.
Sir, DCA now has become APA. It is only a change of nomenclature.
Yes.
DCA has become APA, and APA is to be, the scheme for APA is to be formulated, and that scheme is there at annexure at page 20A.
Guideline has been geologically seen the guideline. What is the guideline? Next page geologically seen. What the
That is 20A. That is what he has just read.
Yes.
page 20.
That is what he has read.
Page 20.
Then there's nothing. You give him that amount in terms of page 25
Allowance below geologically seen. Paragraph 2
of
of page 20. Page 20 of the supplementary affidavit.
20. 8th August. Office memorandum of 8th August. Yes, that he has just read from that. He has read that document.
That was not placed.
Oh, that is placed, sir. That is at page 28. It is the same document.
020.
That is the same document that he has read.
The stand we have taken before the authority below before this tribunal below, wherein below it is that the allowance stand abolish the dual charge. Because President pleased to decide the eligible employees shall be covered and give additional allowances, not that transmitted from the dual charge to additional pay. Your lordship, this second, an employee formally appointed to hold the charge of the duty higher post below, your lordship, is the higher post. In addition to this duty of his own post, will be entitled to draw the pay would be admissible to him if he is appointed to higher post on regular basis, or 10% of present basic certain employee formally appointed on hold full charge of the duties of a post on similar level as on post, in addition duties on post entitled to pay such and such. Now the additional pay should be paid and with the whole currency. Then, my lord, you will say kindly see what stand we have taken, my lord.
Change the name of Where is your letter of 28/7/21? 28/7/21.
ওরা দেখিয়েছে যেটা।
At page 28. Page 28. Have you challenged this
Yes.
order?
Yes.
You have a
Initially, I went to CAT, I went to Central Administrative Tribunal, my lord. And after,
challenge this order of 28/7/21.
yes, that is my challenge.
Where is that?
And that is now against the said letter, I went to CAT, my lord.
CAT.
Thereafter, my lord, CAT, initially the CAT was trying to comprehensive representation, my lord. And I have filed the comprehensive representation, my lord.
That
Page
was
number
not
20.
interfered with.
Huh?
That was not interfered with.
Only the plea that the only lower post, that is.
The
But
CAT,
actually, my-
when you challenge this order of 28/7/21,
Yes.
the CAT did not set it aside.
Now,
It only said you filed
initially
representation.
consider why this matter is simple matter, why not the consider? But I filed the compensation representation. Thereafter, my lord, again I went to CAT. A CAT has only taken the plea only that there is a lower post.
When you filed your representation, did they pass any order?
After the order, initial order, my lord, CAT. And thereafter, again I challenge.
Where is that order passed by the, after the CAT's order?
After the CAT's order, the CAT order is there, my lord. The representation, my lord, page
Written
number.
order page 39.
Page?
Page number.
Page 39 written order.
This is after consideration. This is after consideration in terms of the administrative tribunal's order.
When made the railway has taken the plea only, that was the post of lower post, my lord. In page number 21A, my lord, the 3C, this arrangement cannot continue for a particular vacant post for more than 1 year. And I have taken, admittedly, I have taken the charge of 17 months continuously. That is the violation of the circular. But they are taking the plea, they are taking the argument, the page number para 6, additional post will not be allowed in the law officer. But once they have violated the circular initially, 17 months continuous I have taken the charge, my lord. And not only that, admittedly, there was senior laws post and more than 25 lakhs they have railway saved. But only the dual charge, 10% of the dual charge announced they have to pay, my lord. That is.
What was the scale of your post, original post?
What is the scale? 6,600, my lord.
And what is the scale of the law officer arbitration?
Actually, law officer 48,000 law officer and senior LO. After completion of work of senior LO, they are getting the post scale of 6,600, my lord. More or less, that is.
Whether more or less, whether it is less or not, that is only that has to be.
That is less.
Then if it is less, then it is a lower post.
And lower post, but the continuously 17 months the charge violation, the circular has been violated. And not only that, page number 25, GMS sanction. GMS sanction.
So even if it is on a lower post.
Yes.
And it continues for more than 45 days. Which provision says that you are to be paid the additional?
Actually, that post was the law officer post, never. Never, that was the not post of law officer, my lord. Senior LO post all along there was there. Only they have transferred.
You have, according to your own case, you have discharged the duties of law officer arbitration.
No, but page number 24, my lord, 24. Page number 24 again, 2 times task the senior LO arbitration.
Page
24. Sri Mahadev got senior law officer of the duties of the senior law officer, the additional post. That is.
No, but the direction for payment is not for this period.
Yes.
The direction
Again,
is
page number 29, my lord. That is
direction is for the
senior-
earlier period. Direction is not for this period. Page 25,
Yes.
the direction is not for this period. It is for the earlier period.
But 25 general manager has sanctioned the same.
But this is not for this period. Please see the period. This is for
No,
the
that is-
earlier period.
No, that period, for the period. There is-
Please see, sir. It is 25/1/19.
No, in terms of the office order 29/6/18, my lord. That is initial period, my lord.
That is what we are saying.
Ah.
This is for the earlier period. This is for the period when you were discharging the duty of lower post.
Lower post.
This page 25
Ah.
is writing your entitlement for the period when you were discharging duties of lower post.
That was the lower, no lower post,
Yes,
my
it
lord.
is.
They have only, they have
The higher post,
changed the post only.
according to you, the higher post is from 24 to 21, not before that.
And not before that, admitted, my lord.
Then
But if the one, the circular is violated, that how can the post has been
Fine.
continuous 17/1, my lord?
whether this period has been considered 24 to 21,
No, 17/1 can the dual charge may be given?
whether this period has been considered
Yes.
by which order? 24 to 21. This office order of 24 to 21.
24 to 21, no. The initially the 18, 26.
18 was on the lower post. 18 was not on the higher post.
Ah.
That is a different story. But after 24 to 21, when you started discharging duties of the senior law officer, then it is maybe of an
But how the
equivalent-
senior LO post has been, the law officer post, how the senior LO arbitration has
That
been
is
given?
not
That
the
is,
question that we are here to answer. We are
Yes.
not here to answer your such question.
Yes.
We are looking at the document. The document says this officiation from 24 to 21 is on the post of senior law officer.
Ah.
Prior to this, it was on the post of law officer. So after this notification, this office order of 24 to 21, for this period, is there any order by any authority?
No, then no, thereafter nothing order has been, no order has been passed.
This
But the
period-
21A, my lord, this arrangement can be only the
How
45
many
days.
times you will, by saying it 10 times, it will not become better. That we have understood. You have already said 8 or 10 times that it cannot continue. That we have understood.
Yes.
Repeatedly saying that will not improve anything. That we have understood. You need not repeat anymore.
Yes.
We are asking you a different question.
Ah.
Prior to 24 to 21, you were discharging duties of law officer. After 24 to 21, you started discharging the duty of senior law.
Senior law officer, in absence of this.
So after 24 to 21, is there any order directing for payment of additional post allowance?
No. That is admitted. That.
This portion have they given you payment for this period?
No. No payment has been made.
Why this period? Why you are not giving?
Only reply page 7, Milord, paragraph 10. Clarify, it will be clarify.
Which?
Supplementary affidavit, Milord. What our stand, Milord, that has not been controverted before the tribunal.
We are asking you a simple question. You are relying on clause 6. That is all that you have said before the tribunal. That it is for a lower post, therefore he will not get it. After 24 to 21, as per the office order it itself, it is on a higher post. So this period, have you considered?
So we have stated, Milord, that in terms of the notification of the railway board, Milord, they cannot be granted the lower post, Milord, they cannot be, that has to be extended.
We are asking you about annexure P4. This is not the lower post. You have already read it.
No, he is the
You
group-
come to page 24.
group A, your loss can you consider.
You come to page 24 first. What is the post mentioned here? Is it senior law officer? This is not law officer. This is not the same lower post.
Senior law officer, adjutant, headquartered in addition to, that is the Milord, the
So where in your affidavit before the tribunal have you said that
Yes.
the post of senior law officer is also lower post?
Lower
Where have you said?
your
So
logically see,
show it from your affidavit.
page 10 to your logically see, page 7,
Page
page 8, Milord, paragraph, your logically see the paragraph 12. it is stated the applicant while was working as senior law officer, headquarter, Istanbul was temporarily detailed to look after the duties of such and such, addition to his office such and such. Respondent, although overlooking the above, your logical is this.
We are asking you to show where have you said
I got understand whether it is higher post or lower post.
your only ground for resisting the claim is that on lower post he cannot get it. Where have you said that senior law officer also is a lower post? Where have you said? Show. You have not said so.
Milord, only Milord, your logical is one or two line, Milord. That overlooking the above.
That is regarding the 18 period. Why are you reading? That's not relevant.
The arrangement was looking for.
That is not relevant to annexure P4.
Are you satisfied, Milord, to what is that? Whether it
No,
is.
you have to pay him for this period. Whatever it is for senior law officer, it is either you show from your case that senior law officer is also lower, then you can rely on clause 6 of the circular. Otherwise, you cannot rely.
The post of LO arbitration is not post of this such and such as senior post. I will satisfy. I shall produce some.
No, it is not there. How will you do it? You cannot do it. You have to consider and make payment. You will direct. You make payment.
Some time for it.
What time? It is already there.
Your logical is then your logical is page your page 4 below supplementary page 10. Also, 9.
Page?
Post of 9. Middle portion.
In this
In
regard,
terms of para 6 DOT number such and such additional, I am not placing that. In view of the above proposed additional post allowance.
no, please read it from the second paragraph. In this regard, it is stated.
In this regard, it is stated that proposal for grant of additional post allowance in favor of the applicant, or the both the then senior law officer looking upon the duty of the LO arbitration headquarters in addition to its such and such with effect from 2019 was sent to account department such and the account department communicated the finance observation of the on the aforesaid proposal letter such and such for stated. However, in terms of such and such, additional post allowance could not be granted to an employee for holding the
Charge of a lower post.
what
And look at the next paragraph. Yes.
Next, in view of the above below, proposed additional post allowance is not considered admissible since the officer of the higher post senior law officer headquarters has looked after the duties of lower post.
Law officer, not senior law officer.
I got another. Then your logical case is returned back. Then your logical
Yes.
Hence, ultimately, in view of the finance observation, I know the difference of the LO and senior LO. That I am not coming there. Then your logical is the observation. In view of the finance observation, no additional post allowance was paid to the applicant for the duty of the post of such and such.
LO. Again LO, not senior LO.
That is undisputed.
Yes.
I am not coming. Then your logical is the post of LO arbitration is lower post than the senior such and such as senior LO headquarters is senior post and LO arbitration headquarters is group. Your logical is senior LO headquarters as senior LO headquarters, senior post and LO. These are the group. Your logical is that group P junior scale.
Why are you saying how is it relevant?
Because
we are asking you about senior LO, you are reading about LO. It is irrelevant.
That has been stated. Senior
is irrelevant.
Yes. LO,
LO and SRLO are two different things.
And senior LO headquarters.
Yes, they are two different things.
It is quite different, my lord.
In your claim,
Yes, my lord.
Before the CAT, did you claim for this period also?
Period, my lord. From the as per the GM sanction of the general manager order.
That was your only.
Only that how does that? 45 days after the 45 days I have to apply, my lord.
Where is your prayer in the OA?
Yes.
Please show the prayer portion of your OA.
Original application. in the reliefs, my lord. To issue the direction, page number 54. Wait.
That's for duty of 27 days, that will.
Issue the direction upon the respondent and their main and agent to cancel the quash and set aside the impugned reason on speaking order. Speaking order. And also passed by the General Manager, Eastern Railway, Calcutta, forwarded the same by the Deputy Chief Personnel Officer, Eastern Railway, 4th May 2023, upon application rejecting the additional post allowance as claimed by the applicant and reconsidered the claim of the applicant at the 29 period 29/6 to 27 to 18/11/19, 17 months and the further period. To issue the further direction upon the respondent, that is the same.
Malad, he was not page, paragraph 13 of the page 11. On
It will see. We'll see.
only because.
We'll see, but we are prima facie.
Only render the
Lordship, I'm suffering one order issued by the CMOH Canning, whereby I have CMOH, is a medical health officer. Lordship. Now, Lordship, I am a doctor, medical officer, specialist. I was posted as the head of the blood bank. Now I have been demoted and the order has been given effect from today itself. Lordship, I have my remedy before the State Administrative Tribunal. State Administrative Tribunal is closed today. Lordship, I moved this, I wanted the leave from the learned single bench. Lordship, having the determination of Group 6. Lordship, I have been told that you have to only take the leave from the division bench. Since
It is not a CAT matter, it is not a tribunal matter. How can you
Lordship,
grant
since your Lordship is having the 226 jurisdiction to hear out
Our
this,
determination is limited to matters arising out of 223
220
A and B.
as well as Lordship, that is 223
That is
A
not,
tribunal,
sir, you are
Lordship.
trying to move directly before the High Court.
Lordship,
That is not
since it is closed, Lordship, I
We
have the
don't know.
document to that effect to show.
There are two aspects of the matter. One is it is not within our determination. The second is it is available to you tomorrow.
No,
That
order
remedy
will
is
be
available to
effected
you
from
tomorrow.
today.
Today, the law is very settled. Supreme Court says you join, then you challenge the transfer order.
No, this is not a transfer. This is
What your counsel has mentioned. That is a
designation
transfer.
whereby I have been
On a
demoted.
lower post maybe, but it is a
Lordship,
transfer.
it will be effected.
So that is the ground for challenging the transfer.
No, it's Lordship, in that way, Lordship,
Cannot
kindly
grant liberty. It is only the bench which can deal with the matter, which can grant the liberty.
Lordship,
Not-
your Lordship has the supervisory jurisdiction over the tribunal.
Sorry, then that remedy is before another bench, which you know. Either it is before the bench concerned which has to hear the matter, or before
Is your Lordship is having the determination regarding the matter related to
We
Article
don't, sir.
323A and 323B.
not arising out of that. It will just run in circles. It is not arising out of an order passed either by the state or the central administrative.
Lordship,
Or
this
it does not
person
fall in
becomes
our jurisdiction.
remediless in that case.
And
Lordship.
we cannot grant liberty for filing of a matter which is to be considered by a different bench. We cannot do that.
Grateful, Lordship.
Yes.
Yes. So the second period from 24 to 21 is for what period? From 24 to 21 till
Oh, 1 month.
24. There are two periods. One is 24
Ah.
to 21.
Subsequently, two times, my lord, as a senior law officer. And subsequently, it is proved that is the law officer
What
post
are
is
the two periods. Give us the two
period,
periods.
my lord. Yes. 7, 10. বলুন কত টাকা? Further. 27 days and thereafter 14 days.
Give the period, sir. 24 to 21, 1 month. Then what is the period?
Period, my lord, that is.
Which date? From
Or
which
date. 24, my lord, from 24 to
Current one.
2021 to 27 days. That is not the certain period one. Till the date of joining, I was there, my lord. That is
27 days.
27 days.
That is from 24 to
24, 2021.
Then there is another period.
Another period
What is
as
that?
a senior law officer.
What is that period?
That for 27 days. And further page number 29. Further 3/9/2021 to
What we are asking, that is what we are asking. 3/9/21 till 3/9/21 till
3/9/2021 to 14 days.
So these are the two period,
These are the two subsequent two periods.
27 days and 14 days.
Uh-huh.
And the earlier period was how?
Earlier period 17 months.
17.
From 29/6, 2018 to 11/2019, my lord.
9/6/18 to
18 to 11/2009. That is, my lord. The period, my lord, 29/6/2018 to 18/11/2019. Continuous. And admittedly, my lord, the charge has been taken. There was, if the law officer, my lord,
for these two periods, it is less than 45 days.
subsequently it is proved, my lord, there is a post of senior law officer. And if the law officer posted, there are several law officers was there, the law officer was not posted. And how it is also proved that how the law officer in a law officer post senior role has been posted there. It is proved subsequently it is a senior law officer post. And how the law officer post, the senior law officer post has been nominated. Now, how the senior law officer has been posted in a post of law officer?
Learned counsel for learned
Item number 33.
33, my lord, I am appearing for the refund in appeal by Mr. Sushmita Shah Doctor. Mr. Ochinto is appearing for the petitioner, my lord. He has requested my senior to pay an accommodation for your lordship.
Why?
Mr. Ochinto,
Just like that.
my lord, I am instructed by
Adjournment only for adjournment.
my lord, I am not paying for adjournment, my lord. Mr. Ochinto Kumar Banerjee requested my senior.
He has requested you, but why? Cannot just get an adjournment for the asking.
My lord, that is not.
This is the writ petition of 2012. He is not interested, then what can we do? Yes.
My lord, I'm appearing for the respondents, my lord. My lord, this is a case, my lord, where in which, my lord, the ACP benefit that was granted to the petitioners that was subsequently withdrawn, my lord, because the revision scale, revision of the pay scale, my lord, in the entry grade, my lord. That is why that ACP was taken, was withdrawn, my lord. ACP benefit was withdrawn, my lord.
A wrong scale was given. A wrong scale was given.
My lord, a wrong scale. Initially, it was a wrong scale was given, and thereafter we came to a finding that since the entry grade pay scale has already been revised, my lord, and that is why, my lord, it was withdrawn, my lord. Now, my lord, what is their contention? My learned senior friend, Mr. Ochinto Banerjee, is appearing for the petitioner. He requested me to pray for some time. He was here, but they have given, my lord, place before the honorable bench, my lord, which for some time took up the matter. Some judgments of the honorable Supreme Court and High Court and Punjab and Chandigarh Central Administrative Tribunal, my lord. According to him, that which has by dint of the order which has withdrawn the ACP benefit, my lord, that is applicable in our case, and that has been set aside. But in my very humble submission, my lord, that is not the case, because those were in respect of senior.
Yes. Your lordship, kindly take up this matter tomorrow.
No, there are
I am
so
from
many
the midst of a hearing from another.
There are so many
Because
adjournments.
today is the first day, my lord. At a time in 3 courts, the matters have been taken up.
First day does
Yes.
not mean that adjournment has to be granted.
No.
First day does not mean that adjournment has to be granted.
My lord, your lordship, kindly consider. I am addressing before a court. It's my.
Sir, you also please consider, see the number of adjournments, 2012 matter.
My lord,
Last time it was the last adjournment.
My lord, it was not adjourned at my instance.
Oh yes, that is the recording here. You please see the order.
by way of last indulgence.
Not take it.
Mr. Banerjee, learned
Yes.
advocate appearing for the petitioner, prays for an accommodation. As a last chance, the matter is stands
No, it
adjourned.
is there. Kindly consider other adjournments, my lord, when I am submitting. I do not know what has been recorded.
Oh,
fact
you
remains-
must know.
No,
You are expected to know and you are presumed to know.
obviously, no
Cannot
doubt
say you
of
don't
it.
know.
Because I didn't go it, my lord, it was all along being taken
And
up. It
before
was
that also. the
matter
time
was
that-
about to be concluded. There I shall submit, my lord. There is a judgment, my lord, from my lord, Chandigarh bench of Central Administrative Tribunal affirmed by Punjab and Haryana High Court.
Yes.
Subsequently, my lord, the SLP was dismissed. My lord, I shall make a submission. He has
You are
now-
relying upon Rafiq Masih judgment.
No, not Rafiq Masih.
Then
Rafiq Masih is a different aspect altogether. Here, my lord, it was done
it is withdrawal
in a
of
nutshell. Because my lord, today, in fact, my lord, I couldn't go through the brief. The long vacation has gone. The thing is, my lord, at one stretch, my lord, one thing was given. At another stretch, my lord, the same was taken away. This was the case. Because, my lord, from one department, he came, my lord.
What is the benefit that was granted? Which
Yes.
benefit was granted?
Yes, my lord.
Benefit, my lord, was
ACP.
granted. My
First
lord.
ACP or second?
ACP, I shall clarify, my lord, it is there. And the
First
particular,
ACP, my lord.
the particular notification on the basis of which this was.
First ACP in which scale?
My lord, in the scale of 4,000, my lord, kindly bear with me, my lord. In the scale of
4,000.
5,000, 8,000. And later, what happened, my lord, if your lordship kindly allows me for a minute, my lord. These persons, my lord, they were in the they were in the grade of, in the post of postal assistant, sorting assistant, TS class, etc. Thereafter, my lord, they took transfer under Rule 38 of the PNT manual, my lord. And thereafter, they became lower division clerks, my lord, all these persons. Subsequently, at that point of time, my lord, these lower postal assistants, my lord, the post, my lord, that was between lower division clerk and junior accountant. Subsequently, these persons were promoted to the post of junior accountant. Now, at that point of time, when these persons were promoted to the post of junior accountant, my lord, we found that this entry grade, my lord, postal assistant, the entry grade of the postal assistant and the junior accounts, pay scale of the junior accountant, those were at par, my lord. That is why they were given ACP. They were given ACP only taken into consideration their past service, my lord, as postal assistant. Although that was a separate wing, my lord, that was a field wing, and that is an account. This new line of promotion that comes under the accounts wing, my lord. Now, my lord, subsequently, my lord, the scale of the junior accountant that was revised, my lord. That is why, and when the scale of the junior accountant was revised, my lord, that was a higher pay scale than the entry grade, my lord, that is the postal assistant. Now, my lord, the postal assistant pay grade pay scale, my lord, that stands, my lord, at 4,000, 6,000. And that of the junior accountant, my lord, stands at 4,500, 7,000. That is why only on this ground, my lord, the ACP was benefited. ACP benefit was withdrawn, my lord. This is solely on the ground that was erroneously, as has been, I bow down to what has fallen from your lordship, that was erroneously granted. ACP was granted, that was, it has not been recovered because since the matter is pending before your lordships. But that is the ground, my lord. And what
How long did it take you to realize your mistake?
My lord, it took
The benefit, my lord, which was submitted, my lord, it was motionally granted, actually given in 2003. 2003. And subsequently, my lord, it was done. My lord, today I am not ready. Your lordship kindly accommodate for this day only. My lord, let me conclude that matter at least. In a half-hearted manner, my lord, this cannot be done. Most of the petitioners before my lord have already retired by now. Hardly one or two has left.
from 2003. It was
What is the date of the impugned order?
my lord, 18/6/2004, my lord.
No, the tribunal's order.
My lord, I apologize, my lord. I apologize, my lord.
It is 13/4/12.
মুশকিলের ব্যাপার, হ্যাঁ। না না না, বসুন বসুন। এরকম করে কি মামলা হয়?
That is 30th March 2012, my lord.
No, that it is 13/4/12. It was heard on 30th March. It was heard on
My lord,
30th.
I bow down, my lord. I apologize, my lord.
Let us go to the.
কেন এরকম রেকর্ডিং হচ্ছে আপনি জানেন?
They were transferred on their own request.
My lord.
So the tribunal has relied on the clarification of 2006.
Tribunal relied on another administrative tribunal's bench, my lord, Bangalore bench judgment. Subsequently, my lord, another case on the same set of facts was, my lord, in before Chandigarh bench of Central Administrative Tribunal. That was done, my lord. Here the applicants succeeded. Against that, my lord, the Union of India preferred a writ petition before the Punjab and Haryana High Court. Punjab and Haryana High Court upheld the order of the learned tribunal, allowing the writ petition. Then, my lord, it was appealed against by way of a special writ petition. The special writ petition was dismissed. Thereby, my lord, the notification which was there by virtue of which, my lord, this benefit was taken, it was set aside by the
Apex court.
No, it was set aside by the tribunal, my lord, which has attained this finality by virtue of, my lord, dismissal of SLP.
So where are those orders?
But those orders are there, my lord, a bunch is there. Today, my lord, I am, my lord, completely, my lord, in an inconvenient position. Your lord will kindly accommodate me for this day only. Tomorrow, my lord, I shall place.
All right, not today.
Tomorrow, my lord. All these things are there.
In my very humble submission, my lord, it is not applicable in my.
All right, not today. We'll consider.
I shall, my lord, satisfied.
It is there. We'll go through it. We have seen that bunch is there.
Yes, one bunch is there, my lord. I shall place,
I
my
hope
lord.
you have given 2 copies.
Yes, 2 copies. 2 copies it is there. Only thing, my lord, that the actual jargons which are there, my lord, let me, my lord, recapitulate, my lord, once again. For this purpose only.
All right, not today. We have.
Yes.
Item number 34, and I am for the petitioner, my lord. And I am praying for accommodation for 2 days because he has also problem. I am submitting, my lord. Last night, my lord, I got the information that matters in the list. And then I cannot, my lord, I preferred 8 judgments in that case. It has hard. Thereafter, my lord.
Yes.
And this is, my lord, in respect of the pay fixation after promotion.
After promotion.
My lord, petitioner is a senior.
And from which post to which post?
My lord, from junior clerk to senior clerk. This is the one.
Junior clerk to senior
Clerk.
clerk.
And he was, the petitioner was dismissed from service because he was taken few days leave for treatment of his parents.
While he was posted as senior clerk.
No, he was junior clerk.
No, but you said he has promoted.
Promoted from junior clerk to senior clerk.
Senior clerk.
I'm submitting one. But not I cannot complete because in that before that bench, my lord, I referred 8 judgments, which I cannot go through now.
No, let us
It was
see.
largely hard on.
Let us see. Yes.
Hard in August, my lord. So today I cannot go through it, my lord. Then, my lord, he was dismissed from service, taken leave for treatment of his year, my lord. It is continued 6 months.
He was dismissed after promotion.
I'm submitting, my lord. And 6 months leave. He went to join. He was given medical memo for fitness, and then asked to bring the police verification report. And when he went to go for medical treatment, he was told that you have brought the wrong medical memo. He was refused, then again gone back, and he could not procure the police verification problem. By this time, my lord, some years gone, and he was dismissed. Then I preferred application before the tribunal, my lord. Tribunal said, I told that it is not the 4 years delay leave. It was only 6 months. Then, my lord, he preferred appeal. Appeal was allowed, and my lord was restored to his position, and his absence was regularized by my lord giving the special leave, etc. In the meantime, my lord, his junior was promoted to the post of senior clerk. He appealed before the district divisional personnel officer. Divisional personnel officer said, yes, your case will be considered as and when vacancy will arise. But you will we will get the seniority as it was. And he was promoted in 2008. His junior was promoted in 2004. So he was given promotion in 2008 with effect from 2004. But actual benefit was given 2008. And in the meantime, his pay was not at par with his junior. So he preferred appeal before the authority, which was not rejected. Then tribunal said, no, you will not get because you are out of service for some period. But Supreme Court said, when you have posted as a senior to your junior, you will get the benefit of your all benefit as your junior is getting pay salary. That is not the case. Well, I referred 8 judgments, my lord, but today I cannot place it. That is in your lordship's file also. So if your lordships adjourned it for a day or two, my lord.
No, let us get the facts first. We'll come to the judgment later. Basically, you are claiming arrears.
Yes, my lord. And thereafter, my lord, I was further promoted as office superintendent. Now I am functioning as office superintendent.
Your claim in this proceeding is only for arrears.
Arrears, my lord.
That is all.
My lord.
Because on a
And I am
notional
claiming
basis, you have
on
been
the
granted,
basis of the Supreme Court judgment.
on notional basis, you have been granted the seniority because
Well, I will get, Supreme Court said,
let us
even
see.
you will get. My lord, also can take up in any day, my lord. My landed friend also have problem because he has faced high opponents.
I've already submitted my written notes of both the sides. And list of bids of the that will be. But the
Well,
confidential formulation of the opinion.
let it be in any day, my lord, on Friday or any day. That's it. My lord, all my judgments given in the file, that is in the file, but I could not go.
I'm not asking for a parity with his junior.
No, he is not. You have granted him the parity. He is asking for benefits for the period, 5-year period, when he was absent.
No, that time I was not. I joined before
You
few
were
days.
granted the benefit in 2006.
I was 2005.
No, you were granted in 2006.
Mhm.
After the proceeding was concluded,
I was proceedings concluded in 2004. I preferred appeal.
you
Then
were
I-
absent till 2005. How could it have completed?
No,
in
up to 2004, my lord.
No, 2005, sir. From 99 to 2005, you were absent.
No, 99 is wrong, my lord. Because
That
there's
you
another
cannot say.
proceeding.
That you cannot say because that order you have not challenged.
That is
That you cannot say that it
Malad,
was
that is-
wrong because that order you have not challenged. That
that
order
is
has
not,
already
Malad.
been passed.
that railway has been granted regularized my service. So
Therefore,
everything. So
because they said even though you are absent from 99,
Hmm.
there is 3 kinds of leave available
no,
to you.
99 there's another proceedings and I was dropped one increment and that is non-cumulative. I got it back, so it cannot be
Therefore, we said that all those periods are, it is now closed.
Hmm.
Now you cannot say that it is not correct. Whatever you were to
that is
get,
my that is my lord.
that
That is,
period-
but I have given seniority. I am senior.
you are,
Still I am senior.
you said Mr. X, who is junior to you, was promoted.
Railway said I am senior.
Yeah,
Railway said I am
according to
senior. I
his-
am given
According to his promotion, as per law, you have been granted the promotion,
Hmm.
but it is notional until 2006.
and my
From
lord, he said
2006, you have been given the actual
my
benefit.
position is above my junior.
That they are not disputing.
That is my
That is not in dispute.
Supreme Court say in that case, my lord, I will get the benefit of the
They
at
have
least
given,
with the junior.
they have given it to you.
No, that is not.
Oh, yes, they have given it to you,
But
but they
I'll
have given
show
it
one-
from
I'll
a
show one
particular date. They have
So
given it.
page to page, my lord.
They have given it to you from 29 to 2008.
No, that is.
You say that you give it to
I
me from
got
the
pro-
date he got it.
I was given promotion in 2008, saying that you will get benefit from the date of promotion of your junior. It has
Yes,
been given.
yes, and that actual, not actual, notional benefit.
Notional benefit. My
Notional-
benefit will be dependent. So, Malad, Supreme Court also said that notional benefit, if it is given, you will get benefit that period also.
So then what is notional benefit?
That is Supreme Court said, no, notional benefit.
Notional benefit means actual benefit.
Supreme Court said.
Let us see any judgment that notional benefits means actual benefit.
Kindly give it, I'll show that.
We have got the judgments.
I've given bunch, two
We have
bunch.
got it right here.
I have not read it, Malad. I could not read it because today morning I
How
found
can it be that notional benefit means actual benefit?
Also.
Im-
There's another
cannot be.
judgment also. If it any day, Malad, I'll press it.
And what the tribunal has held.
That I could not read it today, my lord. Losses kindly. I've seen it before 4 months. And last occasion adjournment was asked to take, my lord, because I'm before your lordship that time.
Yes.
Before your lordship that time with civil matters.
Yes.
So that time adjourned. Lordship, keep it any day. Ballot.
As prayed, matter is adjourned to give the date of Wednesday.
Monday, my lord.
Day after two.
Get full man. Yeah.
Item number 35.
For 35, I am for the petition. My lord, may I kindly see the last order of 2nd September 2024, by the coordinate bench directed one Mr. Bhudev Chatterjee to appear for the respondents in this revision, in this application. My lord.
Number 1. Actually, I have been appointed by this court, my lord, to represent all the respondents. But difficulty arose that subsequently, my lord, the Kendriya Vidyalaya, they telephoned. We have our independent advocate, Mr. Bagh.
And I also had a talk with Mr. Bag also that he would come and he would represent. So virtually, my lord, I am now only appearing on behalf of Union of India. I have nothing to say in this matter. Because their main prayer is, my lord, against the Kendriya Vidyalaya.
Against?
Against the Kendriya Vidyalaya.
My employer. But what happened, my lord?
Who was the employer?
My Kendriya Vidyalaya Sangathan.
Kendriya Vidya
Kendriya Vidyalaya Sangathan.
Sangathan. So who is representing the Kendriya Vidya?
Madam, previously Mr. R.N. Bag was appearing. I intended to serve a notice upon him, but he refused on the plea that he is no longer in this matter. Subsequently, I filed an affidavit of service before the coordinate bench. Coordinate bench directed Mr. Chatterjee to appear and directed the department to regularize his appointment with a junior of his choice. Now, after 22nd of September 2024, Madam, in the meantime, Puja vacation intervened and the matter could not be taken up, hence before your lordship after change of determination.
And now you are saying that they have informed you that Mr. Bag will appear.
Will appear. I already contacted them. Because actually, my lord, I also told them that yes, this is the situation I have to concede before the court. So far, my lord, the merits of the matter is concerned. I have gone through the relevant orders. What I find, my lord, so far the appellate order is there. The appellate order is not, my lord, sound order. So I, on the last occasion, my lord, I submitted it before the honorable court also. That it is a fit case where remand may be, my lord.
No, my lord, I object to the submission with the order 41.
Either he is appearing for them or he is not appearing. That is the preliminary thing.
How I can make submission, but difficult is that I already had a talk with them. At this stage, if I make any submission.
He is saying that he has been asked not to appear for them.
So far as the remand is concerned, my lord,
Rising out of proceeding.
departmental proceedings, total violation of principle of natural justice, no documents have been supplied to the delinquent employee, and no witness of the defense witness has been made available. A series of defense witness has been produced by the delinquent employee to the
You filed a reply.
No, there is no opposition been filed.
No, you filed a reply in the proceeding.
Yes, I
Reply to
filed.
charge memo.
Yes, challenging to the reply to the inquiry report I have filed. That was been taken into consideration by the.
Reply to inquiry report. Your WS in response to the charge memo.
Yes.
That you have filed.
Yes.
And there you have requested for documents.
Immediately after the filing of the charge sheet, my lord, I have made a requisition for supply of certain documents.
That is what we are asking you after the charge memo was submitted.
Yes.
Did you file a reply or you only requested for documents?
No, I filed a reply as well as some additional documents.
Additional documents for
short for, because I have short for the witness.
All right, whatever. Then they did not supply the documents.
They did not supply. Out of 30 documents, only 5 were given inspection. Copies were not given. Inquiry officer said that if it is not a confidential document, then you must supply. To the inquiry officer directed the presenting officer that you supply all the documents if those are not confidential documents. The presenting officer on the next date supplied, give inspection of 5 documents. So out of 30 documents. So far as 25 documents, there is no whisper. And those are, it is not the case that all the documents are confidential documents that cannot be produced by the presenting officer before the inquiry committee. And moreover, the charge is against that I have used abusive language. Against the principal.
You are a teacher.
I am a teacher. But the main person is the principal whom I have made the abusive language. Neither he has made any statement, nor he has been produced as a witness before the inquiry committee.
No, there are also charges that you have delayed the conduct of examination.
Yes, for that reason, I have sought for the departmental proceedings for conducting an inquiry, for conducting an examination. There is a procedure that if in case of exigencies there is a delay of 15 minutes or half an hour, what will the procedure be? What will be the procedure of holding the examination? There is a guideline for holding examination. Those guidelines I have sought for in my the list of documents. Those has not been produced. And the presenting of an inquiry officer was made appraised of the importance of each of every document. The inquiry officer directed the presenting officer, you produce the documents. Only 5 were given inspection. Documents were never handed over to me. And that has been recorded in the minutes of meeting. If the principal accused, I am the principal accused, the delinquent employee, if I make any allegation against my learned friend is bound and duty to make an.
You are asking for additional documents, not the documents based on which the charge memo has been served.
So far as the documents referred to in the charge sheet, but no documents have been referred to in the charge sheet.
It is without reference to any document.
Only some statement of the witnesses.
Whatever it is, that is there in the charge memo.
Yes.
Either they bring home the charges based on those documents or they cannot.
They cannot.
You are asking for additional documents, not the documents based on which they have proceeded against you.
Now, so far as the documents referred.
Give us some additional documents and I want to produce some additional witnesses of. That has been turned down.
So far as the documents are concerned, that are relevant for to prove my innocence.
Whatever it is, but these are not the documents based on which the charge memo has been.
The charge sheet never referred to any documents. They only referred to some of the witnesses on the basis of which charge was framed.
Must be their statement. Must be a statement of these witnesses.
Yes, only
that is a document.
Yes.
How can you say that it's not a document? It is a document.
It is a document, but those documents which would prove my innocence.
That is a different thing. But it is not that they have proceeded against you on the basis of a charge memo based on certain documents which they have not supplied.
No.
That is not the case.
No. That is certainly not.
The case is that when they proceed against you, you say that this is not enough. I want these documents also. I want to produce these persons also. Because it is by this that I can prove my innocence.
Yes. And moreover, there were a statement of 5 witnesses.
So where is that application?
My lord may kindly see.
Reducing additional evidence.
Yes, my lord may kindly see the list of documents relied by delinquent employee.
Where is your application for additional evidence?
Yes, page 108. My lord may kindly see the charge sheet once. I'll place the additional documents, my lord, but they kindly see the charge sheet. Charge sheet at page 99. The article of charges. And thereafter the statement of the witnesses have been made. Kindly see the article of charges once. May I place just the article of Article 1 and Article 2? Prior to that, my lord may kindly see page 99. Thereafter I will come to
page 108.
Yes, my lord.
Your application.
Yes. I beg to state that it would like to inspect the following additional list of documents. So I request you to supply me the Xerox copy to enable me to, for self-defense at the time of further inquiry proceedings. The additional list of documents are as follows. Cumulative examination copies of the socials.
What is the law when you want additional documents or to produce additional evidence? You are required to make an application in what manner?
Before the inquiry officer.
Just like that?
Yes.
Giving a list of the documents?
Yes.
Without explaining what is the requirement, why you require it?
Now, so far as the
Are you not required to say that why you require these documents?
But that depends upon the inquiry officer.
We are asking you the law. We are not asking you the facts of this case.
My lord, so far as the
once you make an application for additional documents or for opportunity to produce additional witness, are you not required to say why, to prove which point, or to defend which issue you are requiring this? Or you can give a list of 101 documents and ask them to give it to you. If they don't, then the inquiry finishes. What is the law we are asking?
My lord, so far as the explanation.
You are required to explain, yes, sir, every document, why you want it, how it is relevant to your case. You have just given a list.
Yes, but so
nothing.
But so
relevance.
My lord, so far as the importance of the documents being referred to, it is not required to be reflected in my application.
No. Let us see the law then. Then let us see the law. See, you are required to give the reason why you require the document. And then the authority, if he refuses it, he is required to assign reasons. You can't just shoot off a letter giving 101 documents that give this to me. That is what you have done.
My lord, may kindly see the minutes of the meeting that I have explained.
That is not the point. The point is, if this is your only point, that
no,
because this evidence was not given to you,
no,
then
apart from
now we have to see the law. Let us see the law.
Apart
what
from
is the requirement? Come
apart
to the
from
CCS.
Apart from the documents.
Let us see the CCS. Yes. What is the provision? How do you apply for grant of additional documents and witness? Are you required to state the reason why you want these documents, for which charge it is relevant, and then whether the inquiry officer is required to consider that, or it can be done in this way, giving a list.
If my lord may kindly, my lord kindly comes to 100 page 114. 114, 114.
No. See, your point is because of this, this inquiry proceeding is vitiated. You are saying because you have been denied the opportunity in the principles of natural justice, because you did not get an adequate opportunity to establish your innocence, because they denied you these documents and the opportunity to produce certain witnesses. So why do you require them? Are you required to say this or not? Let us see the law. Let us see the CCS. CCS, where is the CCS? What is the procedure? What is the Supreme Court judgment on this point?
But so far as the documents is concerned, my lord, there are
Central Civil Services.
judgments to that effect, my lord. My lord may kindly considers, my lord, 1974 Calcutta Law Journal 251.
Yes, sir.
The page number. Kindly considers 1974 CLJ page 251. Paragraph 39, 52, 53, 55, 65.
No. First, what are the facts? In this case, the inspection or production of documents which the petitioner was seeking.
Yes.
Is it from the documents which were along with the charge memo?
No.
Or additional?
Additional.
Let us see.
Paragraph 39. Now we shall deal with the respondent application in respect of the violation of the rules and the principle of natural justice in course of the inquiry proceedings, which according to the respondent deprived him of the reasonable opportunity of defending himself as guaranteed under Article 311(2) of the Constitution of India. The respondent complains about the following violation during the course of the inquiry. The list of witnesses, though called for, were not supplied to the respondent. Documents called for by the respondent were not furnished to him. The inquiry officer refused to call witnesses named by the respondent. Permission was refused by the respondent to be represented by a lawyer. That is not required. So far as 4 is concerned, I am not on. So far as Roman 1, Roman 2 and Roman 3 is concerned, but I am relying on this judgment. And it kindly comes to 52. In case of Bomkesh versus controller of telegraph stores, reported in 67 CWN Calcutta Weekly Notes, 966, the petitioner challenged the order of the inquiry officer of the disciplinary proceeding initiated against him under Article 227 of the Constitution. In this case, the petitioner asked for opportunity to inspect and take extract of certain documents as to enable him to prepare his defense. The respondent controller, however, refused permission to the petitioner to inspect certain documents or to take extract therefrom on the ground that the 3 of the documents were not relevant for the purpose of preparing of defense and that it was again against public interest to allow access to other documents. One of the grounds taken by the petitioner in challenging the order of the inquiry officer was that the Rule 15.3 of the Central CCA rules was violated by the disciplinary authority. The court held that under Rule 15, Sub-Rule 3 of the CCA rules 1957, a government servant has the right to inspect all the documents that he may specify and required for the purpose of preparing his defense. The disciplinary proceedings where the authority may refuse to inspect or taking extract of if he is of the opinion one, that the records are not relevant for the purpose of preparing the defense by the person charged with misconduct, or Roman 2, that it is an against public interest to allow him to access their. This opinion is not, however, a subjective opinion and must be supported by reason to be recorded in writing. The court further observed that the error committed by the respondent controller in that case in allowing inspection in respect of the document that was merely expressed the opinion either they were not relevant for the purpose of preparing defense, or that it was against public interest to allow access to those documents, and why he arrived at that opinion he did not see. The court in that case allowed the petition. It should be noted that in the case, inspection of the document was asked for by the delinquent employee before the submission of a written defense to the charge sheet. Now kindly comes to 53. In case of State of West Bengal versus Shailendranath Bose, AIR 1964, Calcutta 184, equivalent to 68 CW 203, the court was considering the validity of an order of dismissal of the respondent, a government servant. In that case, the charge was submitted to the government on May 19, 1959, and the disciplinary proceeding was started under Rule 45 of the CCS rules. The allegation that the government servant was demand of illegal gratification and the acceptance of the same from the different police officers. Charges were grouped under 4 main heads. By letter dated 27 May 1959, the government servant was asked for copies of various documents, including the statement of the officer that the witness, if any, alleged to have been present at the time of occurrence on 15th of October 1958. The statement of the Sergeant Dhar in respect of some incident and a copy of his own statement alleged to have been made before the Special Officer Enforcement Department. By a letter dated 28 May 1959, the inquiry officer informed the government servant that the copies of the statement of witness would not be supplied at the stage, but he would be offered to an opportunity to inspect the record containing those statements in proper time after he has put in the written statement. The respondent's written statement was put in on June 10, 1959. By a letter on the event date, the respondent again asked for opportunity of defending himself by the supply of the copies of the statement and other papers mentioned in his letter dated 27 May 1959. By a letter dated June 15, 1959, the inquiry officer communicated to the respondent that the copies of the documents would not be supplied to him, but that he might ask for inspection of the record containing evidence so far collected against him. In support of the allegation of the violation of the natural justice in inquiry, one of the ground was taken that the copies were not supplied to the government servant to enable him to cross-examine the witness. It was held that the objection of the respondent that he was seriously handicapped in the matter of cross-examination of the witness because of the non-supply of the copies of the document was a substantial one, and that one could not lose sight of the fact that the respondent had to get rid of the cross-examination of all the witnesses who were going to be examined against him, and that he could only hope to do so effectively if he had the materials for cross-examining them. With regard to some of the documents called for, the court remarked the inquiry officer did not hold that those documents were altogether irrelevant. The appellate court upheld the decision of the trial court by saying that he was justified in coming to the conclusion that the failure to have these documents produced in proper time was a violation of the rules of natural justice, which should have been observed at the inquiry stage. The learned counsel for the appellant commented on that case by saying that there was no preliminary inquiry in that case, and the document asked for by the delinquent employee related to the incident, which was the basis of the charge, and came to the existence on the day of the occurrence, and soon thereafter, in that background, held that those documents should have been supplied after the charges were framed. He further submitted that in that case, documents called for did not relate to any stage of the preliminary investigation, but tended to prove or disprove the charge itself, and were also relied upon by the inquiry authority. According to the learned counsel in the background of the aforesaid facts, court held that the non-supply of these documents amounted to violation of principle of natural justice. It is true that the document in that case did not relate to the preliminary inquiry, but were statement of witnesses and personal diaries of the delinquent officers and other persons of the date of the incident. But on the principle, it does not appear to make any difference whether the documents relate to the preliminary inquiry on the basis of which the charge is framed or other documents. If they are relevant and or called for by the delinquent officer for the purpose of cross-examination in support of his defense. Certainly, if the production of those documents is refused on the ground that they were irrelevant, different
Correct. If
consideration
they
may
are
arise.
relevant and called for by the delinquent. Therefore, we are asking you, where have you said the relevancy of these documents? Now you come to paragraph 67.
Yes, my lord.
Yes.
We now deal with
That is a settled law. There is nothing, sorry, page 301. It is there,
301.
it therefore appears. Now look at this regarding the person he had called for. Last
Yes,
paragraph.
Adensen was called
Just
upon.
see, just see.
Yes, yes. May I just
It therefore appears.
It therefore appears that the respondent did not advance any cogent reason for calling Adensen as a witness in the inquiry proceeding. From the record, it does not appear why it was necessary for the respondent to cross-examine Adensen. It is true that the grounds for the inquiry officer refusal to call for Adensen as a witness are based on record. But in our view, does not necessarily mean that the grounds are untenable. There is no rule either in 57 rules or in 65 rules which enjoins the inquiry officer to call any person named in the government servants as a witness.
That is precisely what we are saying. You have to establish the relevancy and sufficiency. And that is why in the next paragraph, in the view,
Yes, my lord, may I just place the relevant portion is here. We also do not think that the rule 14.6 of the 1957 rules has any relevance with regard to this question. This rule does not require the inquiry officer should call a person named by the government officer as a witness. Under the rule, amongst others, the inquiry officer may decline to examine a witness called for by any one of the parties on the ground his evidence is not relevant or material, and if he does so, he shall record a reason in writing.
Correct. Once you express the sufficiency
But
and
that
relevancy, then he will record it.
That
you don't say where
depends
is the
upon the
question of-
inquiry officer to record.
To the next paragraph.
Yes. In any event, as the request for calling Adensen as a witness was made after 1965 rules came into force, rule 14.6 of the 57 rule does not relevant for the purpose of question under consideration. Because of the change of rules, minor 57 to 65, this 14.6 has been incorporated, and
the court has clearly held that he has not specified the relevancy and sufficiency. Therefore, the inquiry officer has rightly not called for this person. In the next paragraph, it has concluded
now look,
that we find no infirmity in declining to call him. Now that is the same situation.
So far as one witness is concerned, in this case, so far as one witness is concerned.
Show us the sufficiency for one document in that list.
Yes, my lord. My lord, may kindly comes to the relevant page 114 once. What was the observation?
114. Your application, page 108.
Now, my lord, may kindly comes to the documents that I have called for.
Yes. What have you said? Why? For which charge? It is relevant to which charge? To dispel which allegation? To arrive at what conclusion? You cannot just type out a list of documents and say, give it to me, or you don't proceed. That is not, it is not a tool in the hand of the delinquent to throw a spanner in the departmental proceeding. It is there in the hands of the delinquent to avail the opportunity to establish his bona fides, or to establish or demolish the charge or dispel the allegations. So the requisition has to be with reference to the point that he seeks to achieve or the charge that he seeks to meet. That is what has been held by this court in this case also. If they are relevant and called for by the delinquent for the purpose, then certainly this is what the court has held in this case also.
Now, my lord, may kindly comes to 65 once. 65 I have your lordship has pointed out. Now kindly come to page 50, paragraph 55.
No, that is the law, sir. That is the law. You cannot just give a list and say that either you give it or you start writing a judgment why you don't want to give.
But
that is not the law.
But so far as the relevancy of the document is concerned,
you have not said anything.
No, my
page 108.
As per my lord, being a delinquent employee, my lord, facing a charge before the inquiry officer, my bounden duty is to prove my innocence.
No, your bounden
to dispel the charges and to prove my innocence. I will have to disprove the charges.
It is not your duty, it is your opportunity.
No.
It is your opportunity to dispel the charges or to show that you know whatever.
Opportunity vis-a-vis my duty.
No, it is not a duty.
But
if I have opportunity which you may avail, you may not avail. You have the option of not availing.
If a charge has been left,
therefore, it is not a duty. It would have been a duty if you are compelled to respond. You have the option of not participating.
No, since I have say I have already.
It is an opportunity, and for availing that opportunity, there is a particular way. This is not the way. We don't find that this law supports this what you have done.
Now, my lord, may
30 documents you have given.
No, I have
Not one line of sufficiency or relevancy of the document.
Kindly see serial number 9.
Yes. There is nothing.
Kindly see eyewitness of the incident who were proposed for statement before the inquiry officer, where such and such dated 26 is November 2001.
Infirmity apart from this, any other infirmity in the procedure adopted by in the inquiry? Is there any other infirmity alleged apart from this?
Yes, my lord. So far as the my lord may kindly considers the names of the eyewitnesses who have deposed before the inquiry officer, before the preliminary inquiry officer. Statements of these witnesses were recorded. Those goes in favor of the delinquent employee. But those statements were not being made a part of the charge sheet. Only the statement of the witnesses which proves me as a guilty who has been referred to in the charge sheet. Kindly see the importance I have referred to in serial number 9 at page 109. Kindly considers. Page 109, serial number 9. 5 witnesses have given their statement on the same date, on 21st November 2001. And those statement of A.K. Dubey, A. Chakraborty, G. Das, B.L. Singh, and S.K. Jadhav, but those were the statements who have made before the preliminary inquiry officer, on the basis of which charges ought to have been made and taken into consideration. Now, the statement of the witnesses that has been referred to in the charge sheet does not reflect the names of the witnesses who have deposed before the preliminary inquiry officer.
See, even in a criminal proceeding, it is open to the prosecution to tender a witness or not examine a witness. That you cannot compel. Surely not in a departmental proceeding.
For that reason,
in a criminal case, you cannot do it.
It is
no such procedure in a proceeding that you can compel them that you rely on this person because he will depose in my favor.
Those witnesses.
No such law, sir.
May I just indicate to your lordship? May I just indicate to your lordship? It is on a preponderance of probability.
Correct. Correct.
It is not beyond reasonable doubt.
Therefore, we are saying something which is on a higher proof, based on a higher degree of proof. Even there, it is not open for you to say that they must examine all the witnesses
so far as the calling
who are in your favor.
Now, my lord may kindly consider.
There is no question of that being said in this.
My lord may kindly consider, but since those documents were of the eyewitnesses were not been produced.
Document we have already considered. Now we asked you whether there is any other point.
Yes, my lord. The second, my defense witness was also not called for. I have named for certain defense witnesses.
There is that.
My lord may kindly comes to list of the at page 120.
Again, same. No relevance.
Page 121. And with the deepest respect, my lord, may I just indicate to lordship, the inquiry officer has been made aware of the importance of all the documents and the witnesses. And so far as the witnesses is concerned, my lord,
where is the procedure? Let us see.
Where
the CCS?
The CCS rules I have not brought today.
This is the only document you are required to come with to establish this. Judgment will come after the provision. We find that nothing sufficiency or relevancy, you have not stated a word even in regard to the witnesses.
So far as
document nor witness.
So far as the witnesses are concerned, my lord, these are my defense witnesses. My lord may kindly considers one aspect.
So a witness and evidence we have seen. Anything else?
But so far as the witness is concerned, my lord, kindly considers serial number 5 to 9. These are the persons who have been present before the preliminary inquiry officer. They made a statement before the preliminary inquiry officer.
That you have already submitted. You say that it was to your favor and therefore they should not have been.
Since the documents have not been supplied, the statement of the witness not been supplied, I have called for them as my witness. But those witnesses are required to be.
Even here, you don't say that these 5 to 9 have deposed in my favor in the preliminary.
Yes, my lord, may kindly see my in my statement I have said. Page 100 page 108. Page 109 rather. Eyewitnesses of the incident who were proposed for statement before the preliminary inquiry officer, KVS, Kolkata, dated 26th of November 2001. Statement dated 21st November 2001. On the event date, all have they made their statements. These statements, my lord, before the inquiry, I am required to prove my innocence as well as to prove not guilty. Now, if I have stated that these are the eyewitness to the incident. They have made a statement before the preliminary inquiry officer. Preliminary inquiry officer, the disciplinary authority at the framing of the at the time of framing of the charge sheet did not take into consideration the statement of the eyewitnesses. So it is my bounden duty to call for those witnesses or the statements made before the preliminary inquiry officer based on which the disciplinary authority has framed the charges, my lord, to prove my innocence. Now, so far as the name of the delinquent employee, so far as the witnesses of the concern, my lord, I have mentioned that these are my witnesses. I am required to the presenting officer of the inquiry, preliminary inquiry officer before the preliminary inquiry before the presenting officer or the inquiry officer. I am to prove my innocence by producing them as a witness and cross-examine. Those opportunities having been not made available to me, this is a violative of Article 311, Sub-Article 2 of the Constitution of India, if your my lord may kindly consider. And so far as the relevancy of witness is concerned and the relevancy of the document is concerned, those are being explained to the inquiry officer. Inquiry officer said that if it is not a confidential document, presenting officer on the next date must produce all the documents. And no date has been fixed for the production of the defense witnesses.
These documents were allowed by the inquiry officer.
Yes.
Where is that order?
Kindly comes to page 114.
Hundred
114. This is a statement of the minutes of the meeting. Extract of the minutes of meeting, order sheet. Inquiry officer to both. The next date of hearing is 20th August 2002, Tuesday. The presenting officer is asked to provide original document for inspection of the charged employee. Charged officer has also asked for some additional documents. He is directed to give the list of the documents so that he may be handed over to him on 20th August 2002. He should give him the list before 15th August 2002. Now kindly come to page 116. Presenting officer to the inquiry officer and the charged employee. Last one. The additional documents demanded by the charged officer by letter dated 12th of August 2002 consist of...
Where are you reading?
The third line, third paragraph, presenting page 116, 116. The additional documents demanded by the charged officer by letter dated 12th August 2002 consist of 30 number. Most of them are not related to the proceeding. However, the documents related to the case and which are not confidential in nature will be searched out by the CRPF Durgapur and will be produced on the next date of hearing. Now kindly comes to the page 117.
By the CRPF? Why CRPF?
They are the custodian. Because he was at that relevant point of time, Kendriya Vidyalaya, CRPF. Now kindly comes to the last portion of the next page. Presenting officer to the inquiry officer. The additional documents demanded by the charged employee by letter dated 12th August 2002 containing 30 number of documents are not at all related to this case. However, the documents mentioned in 1, 2, 4, 5, 6 are produced in original for inspection by the charged employee. Now next page. The rest of the documents from serial number 3 and 7 to 30 are not relevant to this case and hence I am not intended to produce them. Next, what this is. You may inspect the documents mentioned above and put your signature on them presenting officer shows the charge employee through the inquiry officer. Only inspection was given. They say that is not relevant. Why it is not relevant? When the inquiry officer is directing the presenting officer, you produce all the documents. Give the Xerox copy. Now, presenting officer is saying the inquiry officer, those are not relevant. Now, the presenting officer, he himself decides the grounds of defense of the delinquent employee. So, out of 30 documents, I have been given inspection of 5. Now, other 24 documents, 26 for 25 documents rather, there is no whisper. How is it irrelevant? Because the inquiry officer said that if it is a confidential document, you did not. But if it is not, you should produce. It is not the case that it is a confidential document, that it will prejudice the functioning of the organization. Now, I being a delinquent employee, if I have been not been given opportunity to meet out the opportunities what has fallen from your lordship to prove my innocence or to disprove the guilt, then I am prejudiced. Now, my lord, may kindly comes to the charge sheet once. At page 98. There are 2 charges. Firstly, that so far as the initiation of the examination of social science of class 4 section A is concerned, that has been delayed by half an hour. Kindly come to the charge sheet once, page 100. And a major penalty has been imposed upon me. I have been reduced to the initial times scale of pay with stoppage of increment by cumulative effect. And the entire period of suspension has been treated as dias. Twofold my lord, punishment has been inflicted upon me.
Yes, you are
Yes,
showing which page?
but I am placing,
No, you were asking us to see some page.
yes, kindly come to the chart sheet. Page 100. It starts at page 99. 99, my lord, may kindly comes to 99. The two charges. First charge is that the examination for the purpose for the class 4 section A was started half an hour belated. It was supposed to start at 8:30 a.m. in the morning. Instead of that, it was been half an hour delayed. It started at 9. It is not a case that it has never been commenced or no examination was been held. Second charge is that the said article of charges 2, that the said Sri S.K. Jadhav, PRT, while working as KV the CRPF Durgapur on 21st November 2001, used unparliamentary and filthy words addressing to Arjun Prasad, principal KV CRPF Durgapur and other staffs in the headmaster's room. But so far as Arjun Prasad is concerned, if I have made any allegation or unparliamentary or filthy language against the principal, then the principal becomes a prime witness. Now kindly see the list of witnesses. This Arjun Prasad has never made any statement before the inquiry authority, nor he has come and deposed before the disciplinary authority also to prove the allegation that I being the delinquent employee, I have made any unparliamentary words or filthy languages. Then all other witnesses becomes a hearsay evidence.
This is the inquiry report.
Well, an inquiry report your lordship will get at page 185.
81.
185. Well, corresponding
181.
185. 185, but the corresponding pages I have marked with A, that is a type copy. 185 is the Xerox copy. But since it has gone very bad manner, I have given a type copy at the relevant next pages, marking with the A number. Mallory will only consider 186 capital A at the top. My statement has been recorded that I have demanded the documents as well as the witnesses. 186A top. one very relevant, my lord, statement I would like to draw your lordship's kind attention made by the prosecution witness. Although in a scope of a judicial review, your lordship cannot reappreciate the evidence, but so far as the relevance is concerned, my lord, the statement of charges says that I have made unparliamentary and filthy languages against the principal.
This is incomplete. Your type copy is incomplete.
Type copy.
191A. He has to end abruptly.
191A. Thereafter 192 it concludes. 192 it concludes. 191A up to 190 and 191 and 191A type copy I have given. And so far as 192 is concerned, the inquiry officer reports concludes. That is the last page of the inquiry report. Since it was to some extent legible, my lord, a Xerox copy has been provided.
For this, you have not given the type.
It is a change brief, my lord.
No, you say that the next page is legible.
192 is. May I read out to your lordship?
No, it is legible.
Grateful, your lordship.
This is the chart. And you have been allowed an opportunity to make your representation against the findings.
My lord?
Have you been allowed to make your representation against the findings of the
Yes,
inquiry?
yes. I have made a reply to the report of the inquiry officer, page 193. But prior to that, my lord, if my lord may kindly comes to one document, I would like to draw your lordship's kind attention to page 137. That is very relevant. That is a statement by one of the prosecution witness. Although your lordship sitting a judicial review are not appreciating the evidences as an appellate authority, but this document is relevant. This statement made by a prosecution witness is relevant to demonstrate that the prime allegation that I have made an unparliamentary or filthy language against the principal has never made any statement anywhere. Kindly comes to 137 once.
Want that the principal should come before the inquiry officer and say that this man has said these things about me.
But at least, if may I just indicate to
there has to be some sense of
the allegation is that
some sense of respect for the superior authority.
I go down before lordship.
Even if one person stands before the inquiry officer to say that yes, he has used such language, that may be sufficient. It's not required that.
But he has not made any statement.
Mr. Mandal, the headmaster, was there. He is the first witness named by in the chargement. There are 4 or 5 other witnesses. They say they have accompanied him to the principal. Mr. Mandal tried to pacify him that, look, half an hour has lapsed. Whether the question has been said by you or not, please go and conduct the exam. He said no. They took him to the principal's office. The principal tried to convince him. There he has allegedly used filthy language. You want the principal should come and say that he has said this about me.
May I just indicate to lordship?
And if he doesn't, then everything goes.
May I just indicate to lordship? The article of charges, article 2, says that I have made a filthy and unparliamentary.
That is a later part. You are repeatedly saying just that. That is a later part. That is a consequence of the primary allegation against.
Yes. And moreover, no guardian. May I just.
And where is the disciplinary authority's final order?
Yes, my lord, may kindly comes to 203 capital A. (203). I have given a type copy. My lord, may kindly see the last 2 paragraphs. May I just indicate? Now, therefore, the undersigned in his capacity as a disciplinary authority ordered that
When we are engaged in some kind
My
of, please have patience. Yes.
Well, may kindly
We'll not
comes
go
to
into the, we'll not go into the evidence. That's beyond the scope of our
but so far as
review.
may I just rely upon one decision of the 1963
On which point, sir?
on the point of the evidence and documents. One paragraph I will be relying upon. But AIR 1963 Allahabad, page 94, paragraph, the division bench order. May I just hand over to your lordship? May I place it and hand over to your lordship?
May. But we are still, we want to see the provision in the CCS and we want to see the law laid down by the apex court as to how to make a demand for additional evidence or additional witness.
So far as CCS rules is concerned, by that
That
is
you have placed, we have already seen that it is in line with what we were saying. Relevancy and sufficiency has to be explained. Then they are required to meet whether it is sufficient or insufficient. We don't find any such relevancy sufficiency. That judgment, if it is to the contrary, we don't.
May I just indicate to lordship, my lord? It is argued on.
Give us copies.
I do not have the extra copy.
You have only one. Which paragraph you are reading?
Paragraph 13, 14, and 15.
Read.
May I read out?
Please.
It is argued on behalf of the state that the charged officer delayed summoning his defense witnesses, and further that the charged officer never at any stage indicated that the witness he wished to call upon would be benefit for him in meeting other charges. Then
Law is consistent in this regard.
May I just-
You have to say
thereafter,
it is required for this purpose or that purpose.
but that was the argument advanced by the state.
That cannot be repelled.
But that thereafter the court has made an observation.
Yes.
Unless the argument being placed, my lord, the observation cannot have an
Yes.
effect on. The question of delay has to be looked into in the context of the progress of the inquiry, for it cannot be laid down as a general rule that the inquiry officer has the power to fix a date by which the charged officer must summon his defense witnesses, and if they are not summoned by that time, then the inquiry officer has the right to refuse to let the charged officer examine those witnesses in his defense at the inquiry. Where it is found that the charged officer has had adequate opportunity for calling his defense witnesses, and where the charged officer was guilty of laches in calling his witnesses, or where the charged officer resorted to dilatory tactics to delay the inquiry, in such case the inquiry officer may have the power not to examine the defense witness.
Exactly, that is what we are saying.
But there is no delay.
You have failed to summon your witnesses in accordance with law, and where it appears that it is dilatory, where is the question of inquiry?
But so far as the
Not a whisper why you want any of the
but
witnesses
my lord, so far, what has fallen for your lordship, my lord, that against each witness I have not requisitioned as to the importance.
have to say that is a law settled by now.
May I just come thereafter?
Yes.
We have noticed earlier on 25th January 1954, the respondent was asked to put in his list of defense witnesses by 3rd of February 1954. The respondent applied for time for this purpose on 2nd February 1954, which was refused by an order made on 6th February 1954. The respondent again applied for time on 10th February 1954, but no order was passed on his application by the inquiring officer. The respondent put in a list of witnesses on 24th February 1954. No order seems to have been passed either allowing him or to produce those witnesses or refusing him permission. On 25th March 1954, the respondent applied to the Sales Tax Commissioner for fixing a date of examining his defense witnesses, but no date was fixed. In this context, we have also to notice the fact that the respondent by the inquiry, that the report of the inquiry officer was submitted on 8th April 1954. Therefore, it could not be argued, even assuming that the inquiry officer has set 8th April 1954 as the deadline for submitting the report, that could have been delayed or upset the respondent had been permitted to examine the witness, a list of which has been submitted on 24th February 1954. For the inquiry officer could not have fixed a date of examination of the respondent and his witnesses immediately after the list of witnesses have been given to him on 24th February 1954. As it is, we find that the inquiry officer took no steps in regard to this matter. Not even a month after 25th March 1954, the respondent made an application requesting for a date fixed for examination of the defense witnesses. We find it difficult to say that there could be adequate justification in the inquiry officer.
Was one line from the judgment.
Yes,
that reason are not required to be assigned when you are summoning a witness or additional evidence. Why are you reading this? This is relevant to our query. We are repeatedly saying the same thing. You are reading all sorts of things which have no light to shed on our query. Neither this judgment nor this judgment says that just throw a list and then leave it on the inquiry officer to dispel everything. You have to make out sufficiency and relevance. Show us one line from that judgment that the delinquent is not required to show any sufficiency or relevancy and just throw a list of 101 documents, and then it is for the inquiry officer to ponder over it. Why are you unnecessarily reading things which are not relevant to our query? It cannot be, sir. You've seen the law enough. That cannot be a proposition. In fact, the judgments you are reading, it indicates to the contrary, that it cannot be merely for the asking and only to dilate as a dilatory tactics.
May I just indicate one line?
Just show us that line. Don't read unnecessary 5 paragraphs which have no relevancy to our query. We are asking you a specific query and we are repeatedly saying that. Till now, you have not shown us one line to the contrary, but you are reading. Show us that, or it is not there. There is no point in showing other things. We are on a specific point right now. That is what we are trying to clarify. These paragraphs that you are reading has nothing to do with that query. Please show us. We doubt that you will find this, but please show us if you have found it. It's not the way that you will just keep on reading, whether it is relevant to the court's query or not.
May I just indicate one line?
Yes, you show us that. We are asking you repeatedly.
When a person is charged, whether in a departmental proceeding or in a court of law, some authority has to decide whether the charges is made out or not. The decision which is to be taken, is not to be arrived.
Not your point whether they have to answer the charge. Your point is that once I have given a document list, it is for the inquiry officer either to justify not giving or to give all. That is your point, which is before the tribunal also, before the inquiry officer also, before the disciplinary authority. Till now, you have not been able to justify this proposition with reference to any line either in this judgment or in that. That once a delinquent throws a number of documents in his requisition, his job is over. Now it is for the inquiry officer to ponder over every document, see how it is relevant, how not relevant, answer all these queries, or to make all the documents. I don't think you will find that in any case.
May I just indicate to this matter? But so far as the relevancy of the documents and the witnesses,
yes, come to that. That is all that we are asking.
So far as the relevancy of the witnesses,
we have not found at page 108 or 121, not a whisper on the relevance of any of the documents requested by you or any of the witnesses required by you. Nothing. Just here is a list, call them. Here is a list, give it to me. Is all. Now, whether when it is sufficient. You are unnecessarily reading paragraph after paragraph which have no relevance to the court's query. Either in this case nor in that.
But so far as the relevancy of the documents and the witness is concerned, may I just indicate to your Lordship, my lord, the relevancy of the documents and the witnesses.
Either your client has stated it at page 108 or he has not. You cannot improve the factual situation.
No, no. So far as the
Or at
importance,
page 121.
so far as the importance of the
Having failed to do so, whether he still has a right to espouse, that is the only thing which the law has to answer.
now, so far as the importance of the documents is concerned, my lord, I am to explain before the inquiry officer. For before the inquiry, even if I have not indicated.
Therefore, Mr. Counsel, whatever you say will not be accepted merely for your submission. It has to be backed by some kind of either legal provision or a judgment. In our minds, there is something different which we have very clearly expressed to you.
May I
Just saying to the contrary will not help you. And saying to the contrary repeatedly for such a long time will surely not help. Either you have something or you don't have it.
My lord, may I come back with some authority?
Unnecessarily, this court's time is precious.
My lord, may I come back?
The way, we don't expect this from you.
May I come back to next week?
Continuing to read paragraph after paragraph, irrelevant to the court's query. This is not the way. This is not expected before a division or before any.
May I come back next week, my lord, with some authority better?
Counsel, will you be able to inform Mr. Bagh to appear on the next date of hearing?
Also, I have some submissions also to make so that the matter is concerned. But let me
Please,
first of all
make your
tell you what I find with this matter. Make any application where he has stated that yes, these are which documents I require for such and such purpose, no relevance. But nevertheless, if you lordship kindly go through the order of the rather inquiry officer's report, your lordship will find that there well everything has been discussed. My lord, that he sought for certain documents, some of the documents were these were also discussed. Only once maybe that so far the final order was passed. Up to that stage of the inquiry report, well, there cannot be any procedural effect and all these things. Only in the order method, order method, some reasons ought to have been there.
We have been discussing this. He is not coming to the decision. He is unnecessarily harping on something for which he has no justification, but he is reading paragraph after paragraph. It's a one-line order without any reason. You have such a good ground. You have not said it even once. We asked you whether you made your representation. You have no response. Your representation, see how it has been dealt with. Come to 203A, nothing. One line, not sufficient. You are arguing as if you are arguing an appeal. This decision, this evidence, this witness, this document. This is judicial review under 226. Kind of argument. So much time, unnecessary. See the two orders. He is correct. We find that prima facie he is correct. Come to page 192 and page 203A. Abrupt order, no reason whatsoever. He records everything and then says charge proof.
And subsequently, when the client got rather his got agreed, when he prepared the appeal, appellate authority ought to have taken the correct stand.
Correct.
The appellate authority order also will not find any reason. Therefore,
Plus,
I suggested it.
Plus, the appellate at the appellate stage, this infirmity cannot be cured.
Yes.
Once this infirmity has occurred at the initial stage, appellate authority cannot cure it because this is the stage where all the evidence and document has to be considered. You are not arguing one good point you have. The weakest point you are emphasizing for such a long time with reference to material which does not support your submission. Unfortunate. Where is Mr. Bagh? Ask him to be here. You serve a copy on him.
Are served.
No, last order is regularizing his appearance.
Yes, I have served.
You just want to say something or the other, or you want to hear us also?
My lord.
Last order is regularizing his appearance in this proceeding. After that, he says he has been told Mr. Bagh has to appear. You inform Mr. Bagh to be present. If he doesn't appear, or you file it. No, it is, we realize, but then we don't know what to do. What can be done if the respondent doesn't want? If they say that they already have.
বলেছেন আমাকে ডিপার্টমেন্ট তাই জানাচ্ছে এবার ন্যাচারালি আমি সাথে লয়াল নই আপনার ফোন নাম্বার আসুন না ফোন নাম্বার আমি একটু প্রোগ্রামের কাছে কথা বলি দ্যাট ইজ দ্য ডিফিকাল্ট
Authority, Kendriya. Who is in charge of that Kendriya Vidyalaya Sangathan panel?
That is the main party. Actually, I have been asked by court mallet to make service upon the principal. That is responding number 5. Responding number 4. The man in charge of that.
He has said that you should not appear.
No, his officer pilot he made contact with. He said actually I said that yes, this is your probably they are not satisfied with my. They are saying that yes, there will be a full test.
Oh,
And
because
then he said that no, our Mr. Bagh is there, so that's why I said very well. Mr. Bagh appears, then also I have to send the respondent number 1. Here I can make my submission.
So who told you? Respondent number 4 told you.
Respondent number 4 is the main of the Kendriya Vidyalaya.
You spoke to him only.
Yes.
You had talked to him only.
Yes, I have talked with his officer.
Yes.
Today I cannot give the number. আমি তোমায় পরে কালকে দিয়ে দেবো।
Yes.
হ্যাঁ,
Please take it.
Brother, could I send the copy of the order by post to the
Let an affidavit of service be also filed when the matter is taken up next.
but only upon respondent number 4.
Mr. Bag as well as the respondents, both. Yes, okay. Report. First comments.
Item number 36. Item number 37.
My lord, paper book কোটা আছে গো? Supplementary paper book কি আছে গো? My lord, in this matter, I think, my lord, there are 4 paper books at moment. 4 means 2 each, my lord, for the honorable judges. But my lord, after that, we had to file a supplementary paper book that has been filed on 13th of September, which I have mentioned before the erstwhile honorable bench also. Whether those are there in the otherwise, my lord, actually the এই দুটো কি আমাদের প্রিলিমিনারি দুটো এসেই গেছে সাপ্লিমেন্টারি
There are 2 volumes, volume 1 and volume 2.
সাপ্লিমেন্টারি হ্যাঁ ঠিক আছে একটা সাপ্লিমেন্টারি একটাই তো একটা কিন্তু আগে গুলো ছিল কিছু করতে করার কথা
Yes, everything is here.
My lord,
Please proceed.
my lord, may I pray one thing, my lord? I actually, my lord, Mr. D. Purokaisto is appearing in this matter as my learned senior in this matter, my lord. He has been engaged. He is there from the beginning, my lord. But he couldn't come to court today because he has hurt his pelvis and he asked me to pray before your lordship my lord, to fix a date because he can't stand for much time. So my lord, only for this my lord, I will if it is tomorrow or day after tomorrow, my lord, your lordship may fix a date so that he can come up and do the matter. Any time, any date, my lord, your lordship.
Dismissal has been upheld by the tribunal.
Yes, my lord.
Dismissal has been upheld by the
Yes, my lord. Dismissal has been upheld by the tribunal.
He was working as
My lord, doctor, my lord, at Chittaranjan Cancer Institute Hospital, my lord. Actually, my lord, he had sought for an leave for an assignment outside India, which my lord, the director has given him the permission. And after that, my lord, the director being directed by the other higher authorities, my lord, he wanted to withdraw it. That is the main thing.
director is his appointing authority.
No, that is the main thing. My director is not his appointing authority. But my lord, that at page 66, if your lordship comes, sorry, my lord, if your lordship takes the supplementary paper book once, my lord.
So when he requested for leave,
yes, he has given a no objection, recommending him.
NOC has been given.
NOC has been given, and my lord, at page 67, the recommendation has been made by him. At page 68, 69, my lord, the persons who wanted to, who had been appointed in lieu of me in that position, 2 persons, my lord, they has been appointed, and my lord, I have left. Now, my lord,
So there is no permission.
Yes,
there is
my
a
lord.
recommendation, but no permission.
My lord, they say so.
Please allow her. Please, sir, I will hear you. Please, yes.
Yes, my lord, that was the case of the authority, that there was no permission. But my lord, that no permission has never reached me. That has been found in the inquiry report. Your lordship will
No permission has never reached you. What
no,
does that mean?
no, my lord, no letters have been given to me, which has never been reached, never been given to me also. That could not be served upon me also, my lord. And I have replied to
What
everyone.
could not be served upon?
My lord, whatever they are saying that no permission has been granted.
How a no permission can be served on you?
No, my lord, the letter has to be served upon me. That yes, there is
A
no
rejection,
permission, you have to work.
a rejection may be served, but when no order has been passed,
My lord, that is what I'm saying, my lord. If it is a rejection,
is it their case that there was a rejection?
They say so, that there was a rejection, but the rejection letter never reached me. That is what we see. And my lord, even after that, my lord, we will come up before
So
the
let us see where is the charge memo.
My lord, my lord, before the charge memo, my lord, your lordship will find at page 66, 67 is relevant that I have got the no objection.
No, where is the charge memo?
My lord, charge memo will be starting from my lord, page 75, annexure P8.
Of the supplementary?
Yes, supplementary, my lord. My lord, we are on the point of this, my lord, also.
No, it is not the charge that it was rejected. It is the charge that you never got it. They don't say that there is a rejection. Come to page 77, article 1.
Yes. They say that I have not got it.
Without sanction. They don't say after rejection. If it was a rejection, then they may have been required to serve.
They did not do so, my lord. They
There
have
is no
said,
rejection. There is
there
no
is-
sanction.
so, my lord, there was,
There is no question of service.
my lord,
Question service
but
does
there
not
is a
arise.
findings, my lord. Or there is a finding
That
in the
may be, but
inquiry
that's
report.
not a charge. That is not a charge. The charge is that without sanction you have left.
No.
So did you appear in the proceedings?
Yes.
So broadly, what is the infirmity in the process? We are
Yes.
just asking you. Broadly, according to you, what is the infirmity, procedural
My
infirmity?
lord, no charges has been established against me.
So
But
that
still,
is-
I'm dismissed.
That
from
is
the
not a procedural infirmity.
My lord, if
We are not hearing the matter as an appellate authority.
no, my lord,
We are asking you what is the procedural infirmity before the inquiry officer according to you.
my lord, if there is, my lord, if the charges has been framed against me, my lord, if the charges have not been proved, then my lord, the order of dismissal is a.
But that is not something which is open to you to argue before us.
My
That
lord,
you may have argued in appeal. Before us,
my
you
lord,
have
we
to
have-
point out
we
what is the procedural
My lord, we
infirmity.
have. That
So
is
what
we
is
have
the
challenged.
procedural infirmity we are asking?
My lord,
Which procedure has been violated?
but actually the
Not
procedure.
proved is a very vague
First
assertion.
thing, my
We
lord.
are not going to reopen and hear everything like an appeal whether
No,
it is
not.
not.
I'm not on that, my lord.
So
But
we are asking you according to you.
yes, my lord, the
According
first
to the petitioner.
procedural, my lord, difficult. This is that the permission has been whatever, my lord, no objection has been granted by the
No, that
director.
is merits. We
My
are
lord,
not on merits.
I'm saying, my lord.
We are not
let
on
me
merits.
Please, I'm not on merits, my lord.
Yes, you are on
My
merits.
lord, the no objection had been granted by the director. The
We are
disciplinary
not on
authority.
that.
My lord, the disciplinary authority is the director.
So what? We are asking in the inquiry what is
My
the
lord, that
procedure?
itself is an inquiry proceedings.
That
is
cannot be a
written in its
procedural
inquiry
infirmity.
proceedings. What we are
That
saying.
cannot be a procedural infirmity. That, madam, cannot be a procedural
My
infirmity.
lord, the disciplinary authority.
Saying that it is not proved is not a procedural
Well,
infirmity.
I'm not saying it is not proved. I'm saying the disciplinary authority who had granted me the permission, who has granted me the no objection, he is the disciplinary authority. He himself has granted me no objection, shifting his duty or obligations upon me. He should have been a charged officer as well, but he has not been charged.
Okay, so this
Rather,
is-
I have been made a scapegoat. And I have been said that no.
So where is his the permission that he granted?
My lord, that is at page 66.
This is not grant of permission.
Well, the no objection. The next, that was the no objection. I have the pleasure to certify that Dr. Shruti Chakraborty is working as head of the department. The institute has no objection if Dr. Chakraborty applies for foreign assignment.
That is not.
I have done. And my lord, the next page, my lord, at page 67, he has recommended. I therefore recommend that due permission may be granted to Dr. Sujit Chakraborty to leave the country for taking up the assignment of the extraordinary leave at the above mentioned hospital in Malaysia for a period of 2 years. The last paragraph, my lord. Handing over the charges, madam, please. Sorry.
Yes. This is nothing. This also it says only after he obtains leave
My lord,
in
page
accordance with the rules, then only he can avail.
My lord, page 68A. Next page, my lord.
All these are no objections. There is no permission.
Yes. So, my lord, if that is so, my lord, then there are documents also, my lord, 69, 70, that they have appointed persons in lieu of me.
Once you leave, what will they do?
My lord,
Once you leave without permission, what will they do? They will keep it
even
vacant.
if I leave, if
Public need to be
my lord,
served.
if it is so, my lord, then the
When did you leave?
my lord, I left on 29th or 30th of August, maybe. My lord. Exact date is
First
not
August
here.
they have appointed. What can they do after you have left? They will not keep waiting for you.
And my lord, the same officer, my lord, who is giving me no objection, is
the inquiry
cited as
officer or
yes.
whether that
And my lord, I'll come up with the bylaws also, my lord. The bylaws says that he cannot do so. He has no authority to delegate the power. He has no authority to sign here. He himself
delegate the authority for
inquiring officer, appointing any inquiry officer. He has done that.
the director does not have the authority.
No, my lord, not for the A grade officers. Not for the A grade officers. Let me come up with the bylaws, my lord.
The delegatee was below grade A.
Yes. My lord, let us come up with the bylaws, my lord. It will be clear
It
from
is
here.
on record. Where
Yes.
is the bylaw?
My lord, bylaws, I don't think it is on record. But my lord, we can produce the bylaws before your lordship, my lord.
If you want to rely on it, you have no option but
My
to
lord,
produce.
my lord, we will come up with the bylaws if your lordship desires, my lord.
So we'll continue tomorrow.
My lord,
come with the bylaw tomorrow.
My lord. My lord, day after tomorrow will be better, my lord.
All right, day after.
Lordship. Oblige, my lord.
Just